Council, are we all assembled? Can everybody hear me and see me okay?
I can, Your Honour.
Yes, thank you, Your Honour.
Mr. Fennick, you don't seem to have Mr. Montague-Smith, or is he somewhere I can't see? There he. Maybe perhaps that's where he is. No?
President, correct.
Oh, good. All right. Thank you.
Just got my camera off for today.
Screen's too crowded. Thank you. Mr. Hubble, back to you.
Thank you, Your Honour. I left you with a taster yesterday evening of 8 points, which I'm going to develop in relation to the illegality limb of the strikeout application. And the first of those, so my point 1, is the correct position as a matter of English law is that there used to be a narrow rule based on Lord Hoffman in Grey and Thames trains. Let me develop that by reference first to Grey and Thames trains itself, which you will find in the bundle at 2887. And of course, Mr. Fennick has helpfully covered some of the ground in relation to the authorities, and I'll try and avoid taking you to too many passages for a second time. But it is worth reminding ourselves of the facts of Grey. Mr. Grey pleaded guilty to manslaughter on the grounds of diminished responsibility, and he was ordered to be detained under the Mental Health Act 1983. So Grey was a homicide case in which there had been a criminal sentence imposed by the criminal courts. Now, the centrepiece of the application to strike out is paragraph 32 of Lord Hoffman's judgment at 2919, and the narrow rule, as it's been phrased, is identified there by Lord Hoffman as you cannot recover for damage which is the consequence of a sentence imposed upon you for a criminal act. And if you read on, and it becomes relevant later when we get to the judgment of Lord Hamblin in Henderson, that followed on the decision of the Court of Appeal in Clunis and Camden, Islington Health Authority, which is addressed at paragraphs 34 to 35 in the judgment of Lord Hoffman. And that was a Court of Appeal decision, again, involving manslaughter on the grounds of diminished responsibility. So it's another homicide case. And at 37 to 38, and in particular alongside letter D on page 2920 in paragraph 37, the rationale for the narrow rule was said to be the inconsistency between the criminal law, which authorises the damage suffered by a plaintiff in the form of loss of liberty because of their own personal responsibility for the crimes committed, and the claim that the civil law should require someone else to compensate him for that loss of liberty. That's the underlying reasoning identified there. So the following important points follow my submission. First, Grey and its predecessor Clunis were homicide cases. That's homicides self-evidently by individuals. Neither claimant in those cases were corporate entities, so no issues of attribution arose. Attribution, of course, is an issue that arises in respect of companies because they act by human officers in the form of employees and agents. And Grey and Clunis both involve criminal sentences imposed by the criminal courts. They both involve claims in torts, not contracts. And the underlying rationale in Grey was the perceived inconsistency between the criminal law, which imposed the damage through loss of liberty because of a claimant's personal responsibility for the crimes committed, and a claim that the civil law should require that individual to be compensated for that loss of liberty. So the present facts, of course, are a long way away from Grey and Clunis. First, our case involves regulatory fines, not criminal sentences for homicide. And further, our case unusually involves regulatory fines which have been imposed by the same regulator, both on the audited company, the claimants, and the auditor, namely KPMG LLP, who is the third defendant. Second, our case involves corporate entities as the claimants, indeed corporate entities which had innocent directors and innocent shareholders. and which now in effect bring their claims on behalf of innocent creditors. That may be an issue in dispute as to the extent of innocent shareholders, innocent creditors and directors at trial. I don't know. But the evidential position for the purposes of this application is that there were such innocent shareholders and directors, and the evidence is summarised at paragraph 26 of our skeleton at page 1780 for your honour's note. Gray, of course, did not have to and did not engage with any of these distinctions or the questions of attribution. And third, our case involves claims by corporate entities against their auditors arising from the auditor's failure to discharge their duties pursuant to pre-existing contracts. So these are immediate distinguishing features of the facts of this case from Gray. Further, and fundamentally, Your Honour, the English law in relation to the doctrine of illegality has been on a complex and at times tortuous journey from 2009 and the case of Gray and the present day. And in order to fully understand the complexities of that journey, you probably have to sit through 2 days of submission from me alone, which is a reason for a trial. Well, I hope that would be a reason for a trial, but without prejudice to that overarching point, I shall endeavour to identify the key general developments as a matter of English common law between 2009 and today's date, so far as relevant to the claimant's claim in this action. Now, leaving to one side for the moment the separate complexities that arise in relation to one, corporates and attribution, and two, the strict liability exception, the most fundamental change in approach between 2009 and today's date has arisen from the Supreme Court's decision in Patel and Mirza, and the review, and I suggest overhaul, of the doctrine of illegality that was undertaken by Lord Toulson. And you'll find the decision of Patel and Mirza at 3376. Forgive me, I've got a misreference there. 3276, forgive me.
Thank you.
Now, Mr. Patel was again an individual rather than a corporate. He paid £620,000 to the defendant for the purposes of investing in shares using insider information, and the money was not, in fact, invested for that purpose. The claimant sought to recover it via a claim in unjust enrichment, and the defendant resisted that claim on the basis of illegality, suggesting the claimant was required for the purpose of his claim to rely on an illegal agreement. Now, but by this stage, the law of illegality in England and Wales was in a position of some conflict. As Baroness Hurl subsequently put it in Singularis, the panel of no less than 9 Supreme Court justices were convened to hear the appeal because of the perceived conflict between Huanga, Les Laboratoires Servier, and Bilter. And the Supreme Court split 6-3. It's perhaps worth observing, when we come on to some other authorities, with Lord Sumption dissenting in the minority. And Lord Toulson provided the leading judgment. He reviewed the historical authorities, the Law Commission's reviews, and the overseas authorities. He identified the new 3-stage test to replace the reliance test under Tinsley and Milligan. And he found on the facts, applying that test, that wouldn't prevent Mr. Patel's claim. If you go to, please, 3921, 3291, thank you. Lord Toulson summarises Grey and Thames Trains at paragraph 29 to 32, simply as one of a substantial number of authorities reviewed in the course of his judgment. Lord Toulson expresses no view as to how the narrow rule interrelated or interrelates, if at all, with his new 3-stage test. In my submission, he didn't need to, because he was setting out a new approach that was going to be applied going forward. Lord Toulson then set out the new three-stage test, in particular at paragraphs 101 and 120. Paragraph 101 is at 3308, please, at the foot of the page. And Lord Toulson picks up on Professor Burrows' observation that the key question is whether allowing recovery for something that is illegal would produce inconsistency and disharmony in the law and so cause damage to the integrity of the legal system. And he observed that this left open what is meant by inconsistency or disharmony in a particular case. And then letter G, so paragraph 101, he observed it is not a matter to be determined mechanistically. And that, of course, we submit is precisely what the defendants are inviting you to do in this application. Then, in order to decide whether it's harmful to the integrity of the legal system, Lord Toulson identified you first consider the underlying purpose of the prohibition which is being transgressed. Second, you consider conversely any other relevant public bodies rendered ineffective or less effective by denial of the claim. And third, at the foot of the page and then onto the top of page 3309, keeping in mind the possibility of overkill unless the law is applied with a due sense of proportionality. We are, after all, in an area of public policy. And I rely on that expression there that one has to be careful of overkill. He restates the test at paragraph 120, which is page 3313, with a couple of qualifications or enhancements. He identifies that the rationale is whether it's contrary to the public interest to enforce a claim if to do so is harmful to the integrity of the legal system. For step 1, so that's letter A, he adds the addition of whether that purpose will be enhanced by denial of the claim. Step 2 remains the same. Step 3, in relation to proportionality, he raises the question of one has to bear in mind that the punishment is a matter for the criminal courts. And then at the end, towards the end of paragraph 120, the court is not free to decide in an undisciplined way. The public interest is best served by a principled and transparent assessment of considerations identified, rather than by way of the application of a formal approach capable of producing results which appear arbitrary, unjust, or disproportionate. And again, that's an aspect of Lord Toulson's judgment I particularly rely on, because I say that's the trap that the defendants are falling into. There are 4 points I make following on from that review of Lord Toulson's judgment in Patel. That the first is Patel and Mirza undoubtedly overhauled and in some respects changed the English common law of illegality. Thus, the reliance test in Tinsley and Milligan was replaced by Lord Toulson's three-stage test. Lord Toulson imposed no restrictions on the ambit of that test. It was not suggested that it would apply to some situations but not others. He laid down a test to be applied in respect of all situations in which the doctrine of illegality was being considered as a defence to a civil claim. Second, the defendants in this application are inviting this court to adopt precisely the sort of mechanistic or formal approach which Lord Toulson warns against. And third, in my submission, the defendants have to invite the court to adopt this sort of mechanistic approach, because it's obvious that it would be inappropriate to invite this court to reach a definitive conclusion at this interim stage as to the outcome of applying Lord Toulson's three-stage test. There are numerous complex factors in play that can only properly and fairly be assessed by this court at trial. And further, the fact that this is the position simply illustrates my point that the three-stage test has superseded the narrow rule. If applying the three-stage test either would or might give a different result, then that is telling you that it is the three-stage test that should be applied. Fourth, this would be the position even if the claimant, forgive me, that would be the position, even if the claimant was an individual and none of the offences was strict liability. But here the court has the additional complications to address relating to attribution and strict liability. Now, the defendants attempt to answer this by invoking Henderson and Dorset NHS Trust, and you'll see that authority, Your Honour, at 3850. And the defendant's assertion is that the narrow rule has been found by the Supreme Court to be Patel compliant. I submit that that's simply not correct. It involves a misreading and a mischaracterization of the authority of Henderson. Henderson concerned a claim in negligence by a schizophrenic individual against the NHS Trust providing her care, suggesting that but for their negligence she would not have killed her mother, for which she was found guilty of manslaughter on account of diminished responsibility. Lord Hamblin, giving the judgment of the court in Henderson, examined Clunis and Gray and Thames trains and found that both were consistent with the decision in Patel and Mirza. Now, there's nothing remotely surprising about the decision in Henderson. That's because Henderson was another homicide case, following on from Clunis and Gray. But what Lord Hamblin did not do is to say that Lord Hoffman's narrow rule continued to apply to either all criminal sentences, let alone to quasi-criminal sentences. Indeed, such an approach would be obviously incompatible with Lord Toulson's three-stage test and the observations made by Lord Toulson at his paragraphs 101 and 120. The defendants, for their part, Your Honour, rely on paragraphs 76 and 77 in their skeleton arguments. If we go to those, please, at 3907. It's 77 that the defendants place particular reliance on, but 76 is important as well, where Lord Hamblin says, second, Patel concerned a claim in unjust enrichment, but there can be little doubt that it was intended to provide guidance as to the proper approach to the common law illegality defence across civil law more generally. The case it discusses, such as Gray and Hunger, as well as a number of Commonwealth tort law authorities, at paragraph 99, Lord Toulson, JSC, identifies the policy reasons for the doctrine of illegality as a defence to a civil claim. The approach set out in paragraphs 101 and 120 is expressed in general and unqualified terms. So Gray is there referenced in paragraph 76, but Lord Hamblin making clear that the three-stage test is of general application. Now, at 77, Lord Hamblin makes the observation in the second sentence that, well, he says, first of all, Patel is not year zero so far as future illegality cases are concerned, and that would be to disregard the value of precedent built up in various areas of the law to address particular factual situations giving rise to the illegality defence. Those decisions remain of precedential value unless it can be shown they're not compatible with Patel. Now, please note that what Lord Hamblin is referring to there is the precedential value of judgments in particular factual situations, and that they continue to be of use unless they can be shown to be incompatible. So the precedential value is particular factual situations as opposed to wider rules that in some way are said to continue to apply. And you see that, Your Honour, it playing out in the authority by what Lord Hamblin then does, because if you go to 3916 and page 125 and paragraph 125, what Lord Hamblin does is he then undertakes Lord Toulson's three-stage test. but he does it not by reference to saying, oh, well, the narrow rule applies, because the narrow rule's been replaced by the three-stage test. He does it by reference to the particular facts of Henderson. So if you look at 127, 128 and 129, just by way of example, he's looking at the particular issues that arise in relation to the case of Henderson. And he follows that exercise through in detailed fashion by reference to the particular facts of Henderson through to paragraph 144 and then his conclusion at 145 on page 3918. And there he says, the appellants has not shown that Gray should be departed from and Clunis overruled. On the contrary, I consider that the decision in Gray should be affirmed as being Patel compliant. It is how Patel plays out in that particular type of case. The clearly stated public policy-based rules set out in Gray should be applied and followed in comparable cases. So again, Lord Hamblin is saying that the decision, i.e. the outcome in Gray, should be affirmed as being Patel compliant. This is how Patel plays out in that particular type of case, i.e. homicide cases. The public policy rules in Gray should continue to apply in comparable cases. What Lord Hamblin did not do is approach matters on the basis that there was no need to undertake the three-stage test from Patel because Henderson was in some way a narrow rule case. Still less is the narrow rule said to be the deciding factor. The opposite happens. He worked through the three-stage test by reference to the facts of Henderson, which of course were very similar to the facts of Gray and Clunis. So,
Mr. Hubble, Mr. Hubble, can I just ask you about paragraph 126 of Lord Hamblin's judgment, where he refers to the public confidence principle applying to both the narrower and the wider rule. Does that suggest that they are both still alive and well, or how do you explain that?
well, he's referring to Gray and the background in relation to Gray and the existence of the narrow and the wider rule that are identified in Gray. But then when you come to consider the facts of any particular case, you have to do it by reference to a three-stage test. So
Why would he refer to the narrow and the wider rule if he had concluded that Patel had effectively revoked that process of categorization?
Well, I think I put it slightly the other way around, which is here at paragraph 126 and then 127 and onwards. If you look at the top of the page, he is undertaking the Patel three-stage test. So at the top of the page, stage A, the underlying purpose of the prohibition which has been transgressed, and whether that purpose will be enhanced for the denial of the claim. And then he's referring, I quite accept he refers to Gray and he refers to the narrow and the wider rule, but that isn't to supplant the three-stage test. He's saying there are public policy factors that were considered by Lord Hoffman in Gray, said to be applicable to both the wider and the narrower rule. But then you have to apply those public policy factors by reference to the particular facts of the case.
And you contend that if the narrow rule had survived, it would have applied to Henderson, because the facts in Henderson were pretty similar to Gray and Clunis.
Well, yes, and the conclusion of Lord Hamblin in Henderson is consistent with, as it were, the so-called narrow rule. He reaches the conclusion that as a matter of public policy, the Henderson claim shouldn't be allowed to succeed, but he doesn't do it by a sort of mechanistic application of the narrow rule. He doesn't.
So your submission is that if the narrow rule had survived, all of this reasoning of 125 and following would have been irrelevant.
Exactly. It's Mr. Fenwick essentially says the narrow rule survives, and in its full rigor, and he applies a very, I would suggest, restrictive approach to it. But actually, what happens in Henderson is that the Patel three-stage approach is applied. Now, the considerations that went to Lord Hoffman's reasoning in the narrow and wider rule continue to be important policy considerations that have to be applied by reference to the facts of the case. And Henderson is in a trio of cases that are all very specific, very sad homicide cases: Gray, Clunis, Henderson. But Lord Hamlin spends a lot of time considering the three-stage test. He doesn't say, I don't need to. And really, of course, I go on to develop my other 7 reasons, but that's an end to the defendant's application, because the defendant's application hinges on this idea. There's a very strict maxim in English law, the narrow rule. It's got a very narrow exception for strict liability where the claimant apparently has to prove that they've not been at fault at all. And I say that's simply not the case. What one has to follow as a matter of English law, the Patel three-stage test. The factors that were in play in relation to the narrow rule and the wider rule in Gray will be factors to be considered on the facts of the particular case. But there isn't a mechanistic rule. Still less, and I'll come on to develop this, of course, should the DIFC, which has the opportunity of a relatively clean slate, tie itself up in the knots that the English common law has tied itself up in relation to illegality. So that's my submission. I say that the narrow rule has to be seen through the lens of the three-stage test, and that is the exercise which the court in England would have to undertake. I don't say that the factors at play are no longer relevant. They are still relevant, but you have to look at the facts of each case.
Can you just remind me, Mr. Hubble, was Henderson a strikeout or an immediate judgment case?
I think it was. Bear with me.
So just because the three-phase test applies, it doesn't mean that it's necessarily inappropriate for immediate judgment. Does it?
Bear with me. It was a trial of a preliminary issue. My notes direct me to paragraph 30 of the judgment. Bear with me.
Well, that's a little different to summary dismissal.
Yes. Yes, on page 3896. The preliminary issue was heard over 2 days by JJ, who decided the issue in the respondent's favour. So it was a preliminary issue case.
Yes, all right.
I mean, I will be taking you to two more recent English cases where the courts expressed the view that the sort of multifactorial analysis laid out in the three-stage Patel test is something best done at trial, and that will be my submission.
Yes.
So our submission is that the court, we're not living in a world now of a mechanistic application of the narrow rule to any form of fine. A more thoughtful and evaluative exercise is required, and that's one best done at trial. My second point, relatedly, is that we, of course, are dealing with regulatory fines in our case rather than a criminal sentence. So you have my headline submission in relation to the narrow rule in Gray, and that one has to actually look at Patel and the three-stage test. But you then have to think about the points of difference about this particular case. And the first point of difference is that the litigation we are concerned with concerns regulatory fines rather than criminal sentences for homicide. Now, we wouldn't dispute that in principle, a regulatory fine could potentially amount to what is referred to by Lord Sumption in the Servier and Apotex as a quasi-criminal penalty. But that is a world away from saying that the narrow rule continues to apply mechanistically to all criminal cases, and that the narrow rule extends so as to apply to any regulatory fine. I should take you to the case of Les Laboratoire Servier and Apotex because it's relied upon in my learned friend's skeleton argument, and that, please, if I can take you to the judgment of Lord Sumption at 3192 and paragraph 25. But before I take you to the paragraph, can I just position ourselves in relation to Les Laboratoires Servier? But the first thing to say about this authority is that it predates Lord Toulson's review and overhaul of the law in Patel. Indeed, it was one of the cases that was said to be in conflict that needed the 9-person panel in Patel. And I say it's Patel that one must look for the test to apply when considering a defence based on the illegality doctrine. And for your Honour's note, I observed that Lord Sumption was strongly dissenting. He didn't like Lord Toulson's 3-stage test. One gets that from paragraph 265 of his judgment in Patel at page 3356. So what Lord Sumption has to say in Servier has to be seen in that context. It predates Patel, and Lord Sumption was dissenting in Patel. But if you go on to, with that context, if you go on to page 3192, what Lord Sumption had done was to set his own earlier version of 3 questions, which were: what acts constitute turpitude for the purposes of the illegality defence? What relationship must the turpitude have to the claim? On what principles should the turpitude of an agent be attributed to the principal? And at paragraph 25, he identifies turpitude as criminal acts and a limited category of acts that can be described as quasi-criminal because they engage the public interest in the same way. And he gives examples, including towards the foot of that paragraph: infringement of statutory rules enacted for the protection of public interest and attracting civil sanctions of a penal character, such as the competition law considered by Mr. Justice Flo in Safeways. And then at paragraph 29, at the foot of page 3193, he qualifies that general observation by saying, at the foot of page 3193, this applies in particular where the act in question was not in reality the claimant's at all, leaving aside questions of attribution which arise when an agent is involved and which are no part of the present appeal. There is a recognised exception in the category of turpitudinous acts for the cases of strict liability generally arising under statute where the claimant was not privy to the facts making his act unlawful. So even Lord Sumption, who one might describe as it were a hardliner in relation to the illegality doctrine, and who, as I say, was in the dissenting minority in Patel, identified one exception he had to leave to one side, which is questions of attribution which arise when an agent is involved, and we have attribution to deal with in our case. And then he refers to the strict liability exception and the question of when a claimant is or isn't privy to the facts making his acts unlawful. Now, as I understand it, off the back of Lord Sumption's judgment in Servier, the defendants say, 1, these regulatory fines are quasi-criminal. 2, quasi-criminal can count as turpitude. 3, regulatory fines fall within the narrow rule. 4, the court should simply ignore the Patel 3-stage test, as I understand it. And we say that's a house built of sand. The regulatory fines may be quasi-criminal in their nature, but there's no basis for the huge leap by the defendants to the effect that the narrow rule still applies to any criminal sentence of any description. We say there's no basis for that following Patel. And there's certainly no basis for saying the narrow rule has in some way been extended so as to apply not just to criminal sentences, but also to regulatory fines. And we suggest that the narrow rule doesn't survive in that blanket way. Rather, there is an exercise to be undertaken pursuant to the Patel 3-stage test. So the question of whether a regulatory fine, if it's quasi-criminal, falls within the narrow rule doesn't apply. It's just one of the factors. And a regulatory fine may be thought to be very different to a criminal sentence for homicide. It's one of the factors that is going to have to be taken into account when the exercise, the 3-stage Patel exercise, is undertaken. So that's my second point. Turning to my third point, which is attribution. The claimants here are corporate entities, not individuals. So attribution arises as something which the court is going to have to grapple with. So another key point of difference between the facts of the present claim and those of Gray is that we're concerned with corporate entities as claimants rather than individuals, in contrast to the position in Gray, Clunas and Henderson. So on the English authorities, this court will have to grapple with the question of attribution and how it is that the claimants came to be fixed with the liabilities arising from the DFSA fines. Now, this essentially boils down to 2 rival propositions. The defendant's position is that the fines are somehow personal to the claimants. We say that would have to be pursuant to some species of special attribution, and that the consequence of that, so the defendants contend, is the claimants are barred by public policy from seeking damages from a negligent auditor who caused a proportion of those fines to be suffered. That's the defendant's position. And we say that actually the position is a more common position one finds, which is that the companies were required, as between themselves and the regulator, to accept responsibility for the acts or omissions of its employees or agents, directors or employees, via the principles of vicarious liability and agency, but that the conduct of the senior management, conversely, is not attributed to the claimants for the separate purpose of the claim against the negligent auditor. And that's, I suggest, a proposition that has support from the recent Supreme Court authorities. Now, attribution is a very complex area, or the English courts have at least managed to make it very complex. And it was being reviewed by the Supreme Court in Stone and Rolls, Bilter, and most recently Singularis. But the essential point reached in the English authorities is that illegal conduct on the part of agents or employees of a company should not be attributed to the company in respect of a claim against the auditors for failing to identify and report upon that conduct, so long as there are innocent shareholders or innocent directors. So that's where the English law has landed following Stone and Rolls. And on this application, it's common ground that at least for this stage, there were innocent shareholders and innocent directors. And so if we just look at where the key guidance now from the Supreme Court in relation to the question of attribution, one sees that from the judgment of Baroness Hale in Singularis. And for that, if you could please go to 3749. Singularis was a quintscare case, a quintscare duty case, and essentially whether a one-man company in via its liquidators could bring a claim for a breach of a quintsquare duty by the banker. And paragraph 34, in relation to the question of attribution and whether the wrongdoing of the director should be attributed to the company, what Baroness Hale says is, citing from the judge below with approval, at letter E, in her view, what emerged from Bilter was that the answer to any question whether to attribute the knowledge of the fraudulent director of the company is always to be found in consideration of the context and purpose for which the attribution is relevant. I agree, and if that is the guiding principle, then Stone and Rolls can finally be laid to rest. So, in that case, in relation to a claim by the insolvent company against its bank for breach of the quintscare duty, the answer, and we see this from paragraph 37 at 3750, the answer is that the illegal conduct of the director should not be attributed to the company, because to do so would denude the duty owed by the bank of any value in cases where it was most needed. So it would make no sense to attribute the illegal conduct of the director to the company, because then there would in reality never be a quintscare duty owed, which would be a retrograde step. So the task for this court would become to consider the purpose and context of any proposed attribution of the knowledge of the relevant employees and senior management of the claimants in relation to a claim against the negligent auditor. And in relation to that question, the claimant's contention is that the knowledge of the implicated employees and senior management would not be attributed to the claimants in relation to the claimant's claim against the defendants for damages in respect to the DFSA fines, because, similarly to the position in Singularis, that would be to denude the duty owed by the auditors of any effect. So when you're considering a liability that's been arisen for the companies pursuant to the fines, and then the question of a claim over by the companies against the auditors, one has to say, for the purposes of that claim over against the auditors, is the wrongdoing of the employees or directors attributed to the companies so as to prevent the claim? We say no. Our position is analogous to the position of the claimants in Singularis. Now, none of this is necessarily easy and straightforward law, which is all why I would suggest that we should be having a trial. And I suggest that the DIFC might want to decide with some care how it applies, if it does at all, or how it modifies the English common law. But when you look at that, and that's the recent state of the law, it's simply not right to say that the narrow rule still applies, so that any fine imposed on a company bars a claim against a negligent advisor, and that it can only be, narrow rule can only be escaped if it's a strict liability offence. That's just simply not a correct summary of the common law of England and Wales. My learned friend relied on old cases such as R. Leslie and ASCII. I submit they're of limited relevance. R. Leslie was a first instance decision from 1915, where the company appears to have been a one-man company and the sole director was also fined for the same offence. ASCII is 1948 and concerns an individual and not a company. These cases long predate Patel and Mirza. In reality, on the question of attribution, Your Honour, the defendant's case relies on the Court of Appeal authority of Safeway Stores and Twigger, and what is suggested to be a principle of special attribution in respect of regulatory fines. And in respect of this particular link in the defendant's chain of analysis, the defendants have to satisfy this court that 1, Safeway is good law in England and Wales, 2, that it applies to the facts of our case, and 3, that it must be followed in the DIFC. And we say that submission fails at each of those 3 stages. Can I first deal with what is the status of Safeway in England and Wales and whether it remains good law? If we could turn to Safeway, please, at 3136. First, as Your Honour will recall, this is the authority where Lord Sumption, then still at the English Bar, appeared as counsel for the appellant directors and employees on the appeal. Can I direct you to and remind you of the particular statute that was in play in Safeway, which is cited at 3141 at paragraph 11. You'll see the extract from section 36 of the Competition Act. And can I draw your attention specifically to subsection 3, because that becomes very important in understanding what Safeway found. Subsection 3 says the OFT may impose a penalty on undertaking under subsection 1 or 2 only if the OFT is satisfied that the infringement has been committed intentionally or negligently by the undertaking. So those are the words: has been committed intentionally or negligently by the undertaking. The crux of Lord Justice Longmore's reasoning, and my learned friend took you to this paragraph yesterday, but just to remind Your Honour, is at paragraph 23 at page 3144. In essence, his reasoning was that in light of the wording of section 36.3, the fine was personal to the companies, and it would be inconsistent with that liability for them to be able to recover penalties in the civil courts from the defendants. So that was the key reasoning of Lord Justice Longmore. I should also show you, because it becomes relevant when we look at the judicial reaction to Safeway, to the judgment of Lord Justice Pill, which is at page 3148. And he reached his decision on a more policy-based approach. So if one looks at paragraph 44 and 46, he suggests that the policy of that particular statute would be undermined if the undertakings were able to pass on the liability to their employees or their employees' D&O insurers. And his view was that only if the undertaking itself bears the responsibilities and meets the consequences of their non-observance is the public protected. Now, that was an assessment made by reference to the particular statute in play, section 36.3. So then what one has to do is one has to turn to the Supreme Court decision in Bilter to see the reaction of the various law lords and how Safeway was dealt with. And Bilter is at 3201. It was one of the cases in the run-up to Patel and Mirza, but for this purpose, I'm looking at how the law lords dealt with Safeway. First of all, Lord Sumption at 3235 at the foot of the page. And you'll recall, as I've said, that he was counsel for the appellants in Safeway. What he says is that it's alongside letter A at the top of page 3236, is that it's critical to the reasoning that the statute had the peculiarity that the offence was not capable of being committed by the individuals who were directly responsible. The Act imposed prohibition penalty only on the company. The decision is not authority for any proposition applying more generally. So that was how Lord Sumption himself addressed it, that the one law that one might expect to have supported the judgment of the Court of Appeal in Safeway fulsomely actually confines the case to its own particular facts and the own particular statutes. Then, if we could turn to the judgments of Lords Hodge and Toulson at 3257, they deal with Safeway quite comprehensively at paragraphs 157 to 162. At 157, they summarise the reasoning of Lord Justice Longmore and the passage that I took you to, paragraph 23 of his judgment in Safeway. So they summarise that at 157. They make the points at 158 that if that reasoning was sound, it would support the defendant's approach to illegality in the Bilter case. And then at 159, we disagree with the reasoning, i.e. they disagree with the reasoning of the majority judgment of Lord Justice Longmore. We've been greatly helped by the analysis provided by Professor Watts in a characteristically lucid article, Illegality in Agency Law. Professor Watts, of course, being the general editor of Bousted and Reynolds on agency. And then at 160, Safeway's direct liability or personal liability, in the words of the Court of Appeal under the Competition Act, arose through the acts of its directors and employees as its agents. But should the company therefore be denied the right to hold its errant directors and employees to account? And what Professor Watts says simply does not follow that because under the law of agency a principal becomes directly a party to an illegal agreement as a result of its agents' acts, it is thereby to be deprived of its rights under separate contracts, not otherwise illegal, with its employees and other agents to act in its interest and to exercise due care and skill. And we say that Professor Watts is pithily summarising exactly our position there. Now, Safeway was a case involving a claim against directors and employees by the company, rather than a claim by the company against the auditors. But in our submission, the position is exactly the same here. Just because the claimant companies have found themselves fixed with a liability in respect of the regulatory fines, why should that prevent the companies from being able to make a claim over against agents or a claim over against auditors for failing to exercise due care and skill? And then, in the absence of some countervailing policy reasons, it's not just for someone who falls foul of a statute by reason of the acts of its employees or other agents to add to its burdens and disabilities by depriving it of any recourse against those employees or other agents. And that's a passage on which I, for obvious reasons, place considerable reliance, because I say that's very apt to the present situation. Then at 161, unless there are special circumstances, the innocent shareholder should not be made to suffer twice. The reason if Safeway have taken to its logical conclusion would also mean the company could not lawfully dismiss the errant employees or directors. And then at 162, that Safeway may have been justified on the basis of the policy of the Competition Act. So that's a reference to the passage from Lord Justice Pill that I took you to. This may have been a sound reason for striking out the claims, but they express no view as to the merits of the decision. That requires a particular analysis of the statute in question and the competing public policy factors. So Lords Hodge and Toulson expressly held that the reasoning of Lord Justice Longmore, that the liability was personal to the companies, was wrong, and they only went so far as to say that Safeway may have been justified on policy grounds, but expressed no view as to the merits of the actual decision. If we go, please, to 3215, and to the judgment of Lord Newburger. Lord Newburger at paragraph 31 at the foot of the page, he agreed with Lord Sumption's approach and treatment of Safeway, i.e. confining it to its own facts and the particular wording of the particular statute. He did go on to say that he would take a great deal of persuading that the Court of Appeal wasn't right to reach the conclusion on the facts of that particular case and on the facts of that particular statute, but he did not express a concluded opinion. Then at 3222 at paragraph 52, 2/3 of the way down the page, Lord Mance sympathised with the views expressed by Lord Hodge and Toulson. Any decision?
So what was that page number again, Mr. Hubble? Sorry.
3222, Your Honour.
Thank you.
I'm just moving to the final, to the fifth and final law, Lord Mance, and how he dealt with Safeway. So, Lord Mance at 52 sympathised with the views expressed by Lord Hodge and Toulson. Any decision about its correctness must be for another day after full argument. So, of the 5 law lords in Bilter, 2 of them, Lord Sumption and Newburger, confine Safeway to its own facts, i.e. it turns on a particular wording of the statutory regime and is of no wider application. 3 law lords, Lords Toulson, Hodge and Mance, disagreed with the reasoning of Lord Justice Longmore that this was some sort of personal liability, and rather said that only that Lord Justice Pill may have been right on public policy, but expressed no view on the merits of the decision. So it follows that Safeway is an authority of dubious standing in England and Wales. It's been heavily doubted by the Supreme Court and confined to its own facts. I would suggest it offers no wider precedent in England and Wales, let alone in the DIFC. Indeed, the views of the majority of the law lords in Bilter, particularly Lords Toulson, Hodge and Mance, and the extract from the article, and indeed the article of Professor Watts, are strongly supportive of the claimants being able to pursue their claim against the auditors, in this case in respect of the regulatory fines. So the second point in relation to Safeway was, even if one said Safeway was good law in respect to Section 36 of the Competition Act, so that's the Lord Sumption and Newburger, would it apply to the facts of our case? Well, Section 36(3) of the Competition Act expressly stated that a penalty could only be imposed if the OFT was satisfied that the infringement had been committed intentionally or negligently by the undertaking. In contrast, we say, we have the wording in the table to our skeleton, that the key provisions in issue in our case don't expressly or impliedly exclude the operation of the general principles of agency. Certainly each of the offences in respect of the fines levied against AIML, which are by far the majority of the fines, would apply to persons, and we've given the references in the table, which are defined as including a natural person. The position in relation to ACLD is a mix of where the offence could apply to the person as well as the company. But what you get from that is you would have to go through even if one accepted that Safeway was correct, you'd have to go through a complicated exercise of statutory construction or construction of the rules and form a view about whether they're in the same category as Safeway. And that's just not an exercise that's been done by the defendants, and it's not an exercise that should be done at this stage. It would be an exercise for trial. Your Honour, moving on from Safeway, the next case following Safeway that the defendants deal with, which I don't need to take you to, but I'll just deal with briefly, is a Scottish case of Khan and Hussain, which is at page 3711. We say that decision takes matters no further. Mr. Khan was an individual, so the issue of corporate attribution doesn't arise. And second, with respect to Lord Eric, the reasoning in Khan is somewhat perfunctory. It's a decision from 2019, but it doesn't even mention Patel and Mirza. We say, a recent authority from England and Wales, which is much more on point and of much more assistance to the court, is re Mobigo, and that is to be found at 3989, Your Honour. And that's a decision.
3589.
Apologies, 3989.
3989. I'm sure I misheard it. Sorry.
And that's decision of Justice Mullen from 2022. Now, in this case, Your Honour, the liquidator of the company brought an application under Section 212 of the Insolvency Act, seeking a contribution to the assets of the company from its former directors. And the claim alleged that each director had breached their duties, which they owed to the company under the Companies Act, and that had caused the regulator of premium rate phone services to issue the company with a formal reprimand and a fine of 250,000 for breach of the applicable code of practice. So it's a regulatory fine imposed on a company and then a claim by the company to try and recover damages, including in respect to that fine, from the former directors. So at least some parallels with the present case. The defendants applied to strike out the claim invoking Safeway. And if you go to 4002, page 38, the judge has the extract from the Competition Law Act from Safeway. And then at 39, the decision in Safeway has not avoided criticism. This is at the foot of the page. Decision in Safeway has not avoided criticism. In Bilter, the Supreme Court considered the illegality defence again. And the judge essentially, in fact, in even more detail than I did, the judge essentially then looks at those passages from Bilter that I've taken you through already, Your Honour. And over the next considerable few paragraphs, and then he draws the threads together at paragraph 52 onwards, which is at page 4010. And at 4010 at paragraph 52, I've quoted from the above cases in as limited a fashion as I can, but sufficiently, I hope, to make it clear the Supreme Court has consistently stressed that the rules of attribution of wrongdoing to a company and a claim against it by a third party do not bar a claim by the company against its directors for breach of duty, and that the prohibition in Safeway arose from the unusual nature of the statutory regime. Identifies at 53 specific wording of section 36.3 was said to be to generate the personal liability. So that's the infringement has been committed intentionally or negligently by the undertaking. And the judge noted by reference to the code, here I find no similar limitation on the basis of the evidence and arguments in this application. When he's referring to the code, he's referring to the code laid down by the particular regulator. I haven't been able to find the extracts from the code cited in the judgment, but you get some indication at paragraph 54, where the judge says, you would expect clear words in order to exclude the possibility of an action by the company against the directors in respect of the regulatory fine. No such clear words in the code. And then halfway down paragraph 54, in reference to the code before the court there's a sentence that starts, it is true. It is true that there does not appear to be any power to fine an individual within a corporate party, although other sanctions are available but there is equally nothing to satisfy me on this application that the penalty imposed is wholly personal to the party and should not be recoverable by a company from its directors. There are no words equivalent to the phrase committed intentionally or negligently by the undertaking to suggest a restriction to a personal liability of the company. And at 55, nor is there anything to suggest an underlying regulatory policy of the sort contemplated by Lord Justice Pill. And then 56, that does not appear to me to be a point that I can decide in this application. The Bilter cases demonstrate the complexities in this area. The justices were not entirely of one accord as to the decision in Safeway, but stressed the relevance of the factual context. Any decision on its operation in this case must be taken in the context of the facts found at trial. And we commend that approach of Judge Mullin to this court. It follows on from the treatment of Safeway and Bilter, and we would suggest, whilst each case is going to turn on its own facts and the particular rules and statutory provisions and the particular public policy, the overarching approach of what can or can't sensibly be dealt with at an interim stage, and whether these things are best dealt with at trial, is an approach that we commend to the court. Then there is a question in relation to Safeway. The sort of long stop, in a sense, is, well, should it be adopted in the DIFC anyway? We suggest that the various laws and rules breached that gave rise to the regulatory fines in our case do not require that the fines be treated as personal to the claimants. There's no wording equivalent to that found in Section 36 of the Competition Act. And as I'll develop later, the public policy objectives of the DFSA would not be advanced by preventing a claim against the auditors. In any event, in my submission, the DIFC court does not need to and should not tie itself up in the knots that the English common law has rather got itself into in relation to illegality. In my submission, what's likely to be the correct approach for the DIFC court is to have regards to the sort of approach laid down by Lord Toulson and Patel in the three-stage test and modified as appropriate for the particular circumstances of the DIFC. So that those are my submissions in relation to attribution. My fourth point was that various of the contraventions here are strict liability offences, which is a further complicating factor. So that's a further point of difference from Gray, along with the fact that here we have corporate claims and regulatory fines rather than individuals in homicide cases. Various of the offences here are said to be strict liability offences. And even when the narrow rule was enforced in, as it were, all its glory, there were exceptions for strict liability offences. Now, really, my main point in relation to question of strict liability offences is this, Your Honour, because I say that the whole approach of applying the narrow rule very strictly and then looking if there are carves outs and what would be the test for the carve out isn't really the correct approach, following on from Patel and Mirza. But the first point is that this is another variant on the attribution issue. For the purposes of a strict liability offence where the claimant is a company, the issue becomes whether the conduct of the director or employee that gave rise to that strict liability offence should be attributed to the company for the purposes of a claim over against the negligent auditor. And in relation to a strict liability offence, it's even more difficult to understand why the conduct of the director or agent that has resulted in the company being fined on a strict liability basis should be attributed to the company, such that it can't pursue a claim against the auditors. Our submission is the conduct of the director or employee should not be so attributed. It would denude the duty owed by the director of any purpose. the words of Professor Watts ring, if anything, even louder in my submission in relation to strict liability offences. And the second point is that even if, contrary to my contention, you attributed the conduct of the directors or employees to the company, you then have to investigate each of the offences, what they did or didn't require, and whether there was sufficient mens rea so as to amount to turpitude. And that's just not an exercise to be undertaken at this stage. That would be an issue for trial. If one was in the world of a strict liability exception to a narrow rule, one would then have to review each of the statutory provisions and the rules. One would have to look at the particular conduct. It's not a question of just defaulting to the context of the DFSA notices, because that would be a matter for evidence at the trial to identify precisely what had happened and whatever the test for culpability was, whether it had been met. And those are just simply not issues that are appropriate for exploration at this stage. And I'm conscious of the time, so I will, if I may, I will just give my lord the reference that there's also a recent decision of the English courts, Mrs. Justice Collins Rice, in a case called Owa Dali, which is at 4067, and her conclusion, paragraph 95 at 4069, where in the context of strict liability, a very similar sort of exercise to in re Mobigo, where the conclusion is that it's a matter best dealt with at trial. So the thrust of the analysis in both re Mobigo and in Owa Dali is that these sort of issues and these sort of complications are best dealt with at trial. So, Your Honour, that's strict liability, a further complicating factor. Can I turn then to point 5, my point 5, which is when the Patel three-stage test is undertaken, there are powerful arguments in favour of the claim against the auditor's proceeding. As you know, to the extent, if the defendant suggests there's no requirement to undertake the Patel three-stage analysis, I submit that that's simply wrong. It's not the approach laid down in Patel. It's not how the subsequent authorities in England and Wales have approached Patel. Now, in relation to undertaking that three-stage Patel analysis, I reiterate our central point, which is that there are competing considerations and arguments here, which can only be properly and fairly evaluated at trial. And a short application of this sort is simply not the occasion to do justice to such a complex exercise. Without prejudice to that, the essential question is whether to permit the claim would be harmful to the integrity of the legal system. And we submit that to permit the claim would not be so harmful. On the contrary, it would be consistent with the legal system. Taking the first stage from Lord Toulson's three-stage approach, paragraphs 101 and 120, Your Honour will recall that that's a consideration of the underlying purpose of the prohibition which has been transgressed, and whether that purpose will be enhanced by denial of the claim. The first point at stage 1 to identify is that there are in fact 8 different contraventions spread across both sets of DFSA fines, and the strictly correct approach, if we were at trial, may well be to undertake the exercise on an item-by-item basis. Time doesn't permit me to undertake that exercise today, but without prejudice to that overarching point, the underlying purpose of the prohibition is to advance the objectives of the DFSA, which are set out at Article 8.3 of the regulatory law. And if I could direct you to that, please, at 1834. One sees at paragraph 8 the powers, functions and objectives of the DFSA, and in particular subsection 3, in performing its functions and exercising its powers, the DFSA shall pursue the following objectives. Can I highlight B, to foster and maintain confidence in the financial services industry in the DIFC. C, to foster and maintain the financial stability of the financial services industry in the DIFC, including the reduction of systemic risk. D, to prevent, detect and restrain conduct that causes or may cause damage to the reputation of the DIFC through appropriate means, including the imposition of sanctions. And E, to protect direct and indirect users and prospective users of the financial services industry in the DIFC. Now, those are the applicable underlying objectives of the regulatory law. My submission and our submission at trial would be that none of these objectives would be enhanced by denial of the company's claim against the auditors for their failures to identify and report the misconduct to the members of the company that in turn gave rise to the fines. In fact, our submission will be that those four objectives would be enhanced by the bringing of the claim against the auditors. First, because this would advance the public policy aim of protecting shareholders, which in turn fosters and maintains confidence in the financial services industry and the DIFC. And second, because the DIFC itself recognises the fundamental importance of the role of the auditor in the DFSA advancing these objectives. And that's apparent from paragraphs 7.2 and paragraph 7.7 of the decision notice against KPMG LLP, which I took the court to yesterday. Page 782 for Your Honour's note, but you may recall that paragraph 7.71 emphasised the role of the registered auditor in ensuring that the authorised firm's financial statements comply with the IFRS and give a true and fair view, and that is integral to enhancing investor confidence and is paramount as the last line of defence. And that applies directly to objectives B and C. Paragraph 7.72 of the notice, the failure to identify discrepancies in ACL's accounts and the absence of challenge, that applies directly to objective B. Auditors are important in relation to detection. And the risk of misleading information in audit opinions and assurance reports, that applies directly to objective E. And of course, those users of the financial services industry in the DIFC include and would have included the shareholders of the companies and those who are now the innocent creditors of the companies, whose interests would be best served by the pursuit of a claim for recovery of damages to reflect the appropriate proportion of the DFSA fines. So in summary, we say that auditors play an important role as corporate gatekeepers in enhancing investor confidence and maintaining the DIFC's reputation. And that the objectives will be advanced by the claim against the auditors because the compensatory regime has the effect of driving up standards. If audit firms realise that there will be adverse financial implications from poor audits, including via claims from audit clients in respect of regulatory fines, then the audit firms will work to drive up standards. And a finding that regulatory fines on an audit entity could never be recovered from the auditor would have the opposite effect. It would disincentivise the audit profession from driving up standards. The defendants, for their part, place some reliance on the fact that KPMG LLP has already been subject to a fine, as if that meant that this aspect has already been achieved. So one should leave the regulatory fines against the companies for the companies. But that's not correct in my submission. It doesn't address the point that adverse financial consequences in the form of compensation drive good behaviour in audit firms. Second, the fine imposed on KPMG LLP would not seem to be driving up standards in itself, because KPMG LLP's position in this claim, notwithstanding the terms of the fine against it, is that the standards of their audit work was fine. And third, and in any event, there's only been a fine on KPMG LLP relating to ACL, which was the smaller of the DFSA fines. There's been no fine imposed on KPMG Lower Gulf. The defendants invoke the need for a deterrent effect of the fines on AML and ACLD, but as Your Honour observed yesterday, those companies are already insolvent, so it's hard to see why there would be a further or greater deterrent effect. Now, there may be competing points and arguments to which my learned friend Mr. Fenwick can point when we get to this sort of public policy analysis at stage 1 of Patel. But that's a matter for trial. But our submission will be that the illegality defence fails at Patel stage 1. Patel stage 2, Your Honour, involves a consideration of any other relevant public policy on which the denial of the claim would have an impact. First, there is the public policy consideration in favour of allowing an entity who relies on another for professional services in the DIFC to hold that advisor to account. An audit entity who contracts with an auditor for the provision of audit services should be able to pursue a compensatory claim against the auditor for losses caused by breach of contract or negligence on the part of the auditor. And it's particularly important to remember that the duty owed by the auditor is owed to the members of the companies to detect managerial fraud within the companies. It's those members to whom the duty is owed. It's those members who are denied the opportunity as a class to stop the conduct. And secondly, and relatedly, the claimants are not wrongdoers seeking to profit. Rather, the liquidators of the companies are seeking to obtain compensation on behalf of creditors. And in reality, those creditors are never going to be made whole, let alone make a profit. But the companies are entitled to expect the negligent auditors to be held to account. So we say that those public policy considerations at stage 2 militate in favour of the claim proceeding. Then you're on a stage 3 proportionality, and as Lord Toulson puts it, keeping in mind the possibility of overkill. Here we submit that shutting out an otherwise valid claim on the grounds of illegality would clearly not be proportionate. First, these are regulatory fines, which are quasi-criminal at most. Second, the claimants are not seeking to profit from the alleged wrongdoing. Third, the claimants are only seeking to recover that proportion of the DFSA fines properly attributed to the defendant's wrongdoing. And fourth, the court has other mechanisms open to it in order to address, as necessary, any causally relevant culpability on the part of the company's former management, including, for instance, arguments about contributory negligence at trial. So we say, applying the Patel 3-stage approach, the claim would not be barred. But then there is my point 6, which I say also goes to proportionality, and that's what I refer to as the contradiction of the heart of the defendant's application. Your Honour will recall I pointed out that the defendants run a defence on breach that's at odds with the decision notices against KPMG LLP, and the defendants invite the court to make findings on breach and factual causation that are at odds with those decision notices, and so their defence presupposes that there'll be inconsistent future decisions between the court and the decision notices. And I pointed out that defendants shouldn't be entitled to have it both ways. But this point absolutely goes to proportionality and what Lord Toulson refers to as the dangers of overkill. The defendant seeks the following outcome. The claimants are barred by the doctrine of illegality from seeking to recover losses attributable to the DFSA fines on the basis that they are personal to the companies and they cannot in any way act inconsistent with them. It's said that that would undermine the integrity of the legal system in the DIFC. But at the same time, the defendants, would it seem, remain free to advance a defence on liability to the whole claim against them, which invites this court to make findings which are flatly inconsistent with the decision notices against KPMG LLP and the audit partner issued by the same regulator. In other words, the defendant's position must be that they're free to pursue a defence premised on such inconsistency. And what that outcome brings home, in my submission, is not just that the defendant's submissions are wrong in relation to public policy, but the proposed application of the illegality doctrine would be disproportionate. It would be asymmetrical and amount to precisely the sort of overkill which Lord Toulson warned against. Your Honour, my point 8, which I can express shortly, the illegality defence is plainly not suitable for summary determination. What all the above shows is that the illegality defence should not be and cannot be dealt with at this interim stage. The claimants putting matters at their lowest have a real prospect of success, and the claim in respect to the DFSA fines can only be fairly and properly determined at trial. We draw the threads together on that paragraphs 55 to 57 of our skeleton argument, but in short summary, the Patel three-stage test applies. It's fact and context specific and best done at trial. The question of attribution is something that can only sensibly be dealt with at trial. The complexities in relation to strict liability are an additional reason for trial. And the claimant's approach is reflected in the recent authorities in England and Wales that suggest that the defence is unsuited to preliminary determination, including In re Mobigo, which I referred you to, and Owards Alley in the context of strict liability. And on all these points, the court at this stage can't be certain that the defendants are correct. Putting matters at their very lowest, the courts have a real prospect of success to be determined at trial. So my final point in relation to the illegality limb is whether there are other compelling reasons for a trial in any event. And I include within that the question of what actually should be the law and approach adopted by the DIFC. So first, there is my Lord's point as to why it should be assumed that the common law of England and Wales is binding on the DIFC. Your Honour, the answer to that is that it shouldn't be so assumed. The position is more nuanced. I think this application has probably brought home that the doctrine of illegality is not English common law's finest hour. It's rather tied itself up in knots in the authorities. The DIFC has a clean slate, and the DIFC should resist being drawn into a fine analysis or a mechanistic application of historic English cases that are in conflict. The correct approach is likely to be at trial is that the DIFC should undertake a thoughtful and balanced application along the lines of the Patel three-stage test. But it will be a matter for the court in the DIFC as to how to apply and, if appropriate, modify that test. What the DIFC absolutely should not do, I say it's wrong as a matter of law in England, but even if there was doubt about that, what the DIFC should absolutely not do is make mechanistic rules and rigid rules that run the risk of inappropriate and disproportionate outcomes. So that's the first point in relation to DIFC law. Then, my Lord, there's the conundrum, if I can put it that way, as to whether an illegality defence exists at all in the DIFC in respect of claims in contract at present. And of course, if it doesn't, then the claim in contract would have to go to trial. Now, in relation to a claim in tort, Article 56 of the Law of Obligations provides for a form of illegality defence. The reference is at 1925, and that defence would beg all the sort of arguments that I've been addressing in terms of what is or isn't illegality, attribution, causation, and so on. Conversely, there's no such provision in the contract law or in the law of damages and remedies. And on the face of it, there is at present, therefore, no defence of illegality available in respect of claims in contracts in the DIFC. My learned friends invoked the veggie bar in their skeleton, and Mr. Fenwick referred to it yesterday. That my Lords, note the relevant paragraphs are at 3381, but that was a case of the court not enforcing a contract prohibited by statute. it wasn't a classic application of the illegality defence. And in any event, it predated Hamid. Now, my Lord will no doubt be familiar with the DIFC Court of Appeal decision in Hamid. The relevant paragraphs are 4042 to 3. Um,
4042.
4042 is paragraph 105.
Thank you.
That looked at the question of whether judges of the DIFC are free to incorporate common law developments from any common law jurisdiction, or in essence, whether because the DIFC jurisdiction is statutory, the danger of using common law principles to fill gaps is that can amount to making judicial legislation. That's the concern that's identified at paragraph 105. So about 5 lines up from the bottom, reference must therefore be made to that statutory framework to ascertain the scope for proper judicial interpretation and development of DIFC law and to avoid straying into impermissible judicial legislation. And that theme is returned to at 1110, sorry, 110 at the foot of page 4042, and then at 111. And we have something of a role reversal here with Mr. Montague-Smith on the other side, and Mr. Bowden's argument cannot be salvaged by recourse to the general maxim ubi jus ibi remedium as inherent in a common law system. The absence of the torts and DFC law discloses a gap. It has to be recognised that from time to time there are gaps in the remedies available in legal systems. This was until recently there was just such a gap in English law. The reasons already given, if it sought to incorporate the torts and DIFC law, then any reform must be statutory. Such reform would bridge too far for judicial development. And 111, fifthly, there could be no doubt in the English law, very much including English common law, has featured importantly in furnishing the foundations for DIFC law. But it cannot be assumed merely because there has been a common law development in English law that any such development will be transplanted into DIFC law. Sources of DIFC law are not confined to English law. So interesting guidance from the Court of Appeal, not just in relation to the headline question of whether illegality is available as a defence for claims in contract, but what is the role of English common law when one comes to consider that issue. And I would suggest that reinforces the point that the DIFC court does not need to put itself into the straitjacket that the English common law system put itself into for a period of time in relation to illegality. Now, Your Honour, the defendants indicated yesterday that their response to this problem lay in Article 6 of the Judicial Authority Law, which, if we look at 1823, that isn't much of a hook, if I can put it that way, right, for the defendants, Your Honour. It's dealing with governing law. Courts shall apply the centre's law and regulations except where parties to dispute have explicitly agreed that another law shall govern such dispute, provided that such law does not conflict with the public policy and public morals. So it's that qualification is referring to the other law. So if the parties have expressly agreed that another law shall govern the dispute, then that's what will happen, provided that such law does not conflict with the public policy and public morals. So the most that can be taken from Article 6 is that there is a concept of public policy and public morals, and that when you're deciding on governing law, you shouldn't apply another law which conflicts with it. But that's a long way from saying that the English common law defence of illegality, let alone on the basis as submitted by the defendants, should be applied.
I think that there's a provision in the arbitration law too in relation to recognition and enforcement. I think it's Article 44, which specifically refers to public policy of the DIFC. But again, it goes no further than saying that there is such a thing as the public policy of the. Interestingly, it distinguishes between the public policy of the DIFC in relation to recognition, but in relation to enforcement, it refers to the public policy of the UAE.
Right.
So the legislator, the Dubai legislator, has clearly seen fit to distinguish between those two things, which is quite interesting.
Well,
probably not very helpful for this debate.
Your Honour's ahead of me, but I think my submission would still stand, which is that one, the position is unclear in DIFC, but two, the DIFC just doesn't need to get into some of this. No. You've been very patient to hear it all, Your Honour, but in a sense, the DIFC court just doesn't need to get into it, and the DIFC court actually has the opportunity, in this case, at the trial, to consider matters afresh. And it may well be that the Patel three-stage approach is a useful yardstick for the exercise, but it'll be a matter for the court.
Yeah. Or we might look at what the Canadians do.
Well, exactly.
For example.
No, but it's a matter for trial. It's a matter for debate, and it's a matter for trial once the facts have been found at trial. So, Your Honour, I simply flag that raises the oddity that, in addition to perhaps that fundamental point we've just been considering, but the oddity that my submission is that even if the defendant's application was to succeed, it could only succeed on the tort claim, not the contract claim, and then that would leave the contract claim going to court to trial anyway, which would be a nonsense. And in similar vein, my Lord, remember that we are here dealing with but one item of loss suffered by the claimants, albeit a significant one. So the rest of the claimants' claims will be going to trial come what may. A trial with a time estimate of 8 to 10 weeks. So there's going to be a full trial, absent compromise between the parties. There's going to be a full trial, and that trial will likely still have to consider the decision notices, the DFSA investigation, concepts of illegality. So, well, both from a justice and a case management perspective, the proper course is for the claim in respect to the DFSA fines to be determined at trial. This court will then be able to hear the evidence, make findings of fact, hear full submissions on the law, and issue a judgment which can stand as guidance to both commercial entities and legal petitioners in the DIFC on how these issues call to be treated in the DIFC. So, Your Honour, unless I can help further, those are my submissions on the illegality limb. The scope of duty limb, I think I can probably deal within 15 minutes if the transcriber.
Does anybody have contact with the transcriber? Do we know if the transcriber is about to expire?
I don't have any messages, I'm afraid, to pass on, not at this stage. But I will.
Hello, this is the transcriber, if you can hear me.
Yes, we can, thank you. Would you like a break now, or can you go for another 15 minutes?
I'd like one now, please. We're supposed to have one every 90 minutes.
Oh, are you? Oh, I didn't know that. I'm very sorry.
That's okay.
Would you like 20 minutes?
Just 15 would be fine, thank you.
15. Right, very well. We'll adjourn for 15 minutes, which will bring us back a little at 5 minutes to the hour.
Thank you, Your Honour.
So we'll adjourn until then. Thank you. Good. All right. Well, we'll resume then, Mr. Hubble, when you're ready.
Thank you, Your Honour. So, Your Honour, this is part 4, the final part of my submissions, responding to the scope of duty limb of the application to strike out. Now, here the defendants are seeking to make a different point. The application on the illegality doctrine was seeking to strike out a valid claim based on public policy grounds. This limb seeks to assert that the claimant's claim in respect to the DIFC fines has no real prospect of success in itself. And we say that this second limb of the application should be dismissed for 4 reasons. The first is it proceeds on a mischaracterization of the pleaded case and it ignores important sections of the particulars of claim. The second is it proceeds on a basis of a selective and incomplete analysis of the authorities on the scope of an auditor's duty. But the third is that it supports its analysis by, again, a selective and incomplete analysis of the ISAs that apply to the audits undertaken by the defendants. And fourth, even if there was something in this limb of the defendant's application, which I submit there isn't, nevertheless, this is precisely the sort of claim in a developing area of the law that should be determined at trial. Now, on the first of those, which is the pleaded case, I took the court through the particulars of the claim yesterday at some length. In my submission, the pleaded case makes clear that the losses relating to the proportion of the fines falls firmly within the scope of the duty owed by the defendant auditors. Your Honour will recall the duties that were pleaded, not just in respect of ISA 200 and 240, but in respect of ISAs 250 and 260. Breaches of those duties were pleaded and the losses suffered full squarely within the purpose of those duties. So the pleading in my submission is a conventional one, and it pleads the relevant ISAs, it pleads breach of those duties, and the fines or damages attributable to the fines can be said to fall within the duties owed in respect of the ISAs, particularly those relating to law and regulation. My second point, it relates to the authorities. The defendants contend it's no part of the purpose of the defendant's duty of care to prevent the claimant's deliberate misconduct or the imposition of a fine for such misconduct. And in my submission, that approach misunderstands the duty of an auditor. A key part of the defendant's duty we submit as an auditor was to identify financial irregularities and fraud at the audited entity and other misconduct, and then to report on the existence of those financial irregularities and any associated misconduct to the members of the company. It's a key part of the auditor's duties to report on those irregularities so the members can exercise appropriate control over the company. So in their skeleton, they cite the well-known passage from Lord Bridge and Campara and Dickman at 627D, which is at page 2143. It's never sufficient, so it's alongside letter D, it's never sufficient to ask simply whether A owes B a duty of care. It is always necessary to determine the scope of the duty by reference to the kind of damage from which A must take care to serve B harmless. And we, of course, don't dispute that passage at all. We simply say that the claimant's claim in respect to the DLSA fines falls squarely within the kind of damage which the defendant should have taken care to save the companies from. Let me take you relevantly to another equally well-known passage from Campara and Dickman, which is Lord Oliver at 2146, which goes to the purpose of the auditor's function and who it's provided to. So it's from, if I can invite you to read from letters D to G.
Yes. Yes, thank you. I've read that.
Thank you. And we say that that passage is particularly pertinent and applies to the claimants here. That the shareholders as a class should have received a report from the auditors so as to enable them to scrutinise the conduct of the company's affairs and to exercise their collective powers to control or remove those to whom conduct had been confided, in addition with 2146, as per 2146. The point is that the auditors have to undertake an audit aimed at ensuring that, so far as possible, the financial information on the company's affairs accurately reflects the company's position. And that, of course, includes identifying financial irregularities, misappropriations, and or fraud by management. And the purpose of that exercise is twofold. First, to protect the company from the consequences of such undetected errors. And secondly, to provide those charged with governance with reliable intelligence for the purpose of enabling them to scrutinise the conduct of the company's affairs and to exercise their collective powers to control or remove management as necessary. And that's absolutely the position here. The defendants also cite from the judgment of Lord Leggatt in Manchester Building Society. Manchester Building Society is at 3920 and concerned an audit negligence case against Grant Thornton, and there the auditors advised that it was acceptable from an accounting perspective under IFRS for the audit client to enter into hedging transactions, and it subsequently transpired that such transactions were not allowed from an accounting perspective. The transactions had to be closed out and losses were then suffered. The GT's defence in that case echoes what the defendants are saying on this application, namely Grant Thornton in that case asserted that they weren't responsible for the business decisions and commercial behaviour of the audited entity in deciding to enter into these particular hedging transactions which resulted in losses. But that didn't matter. The losses suffered were still within the scope of the duty owed by the auditors when advising on accounting and auditing matters. And I submit that the link in our case between the DFSA fines and the purpose of the audit is in fact much more obvious and straightforward than the link between the losses on the hedging transactions and the purpose of the audit in MBS. So far as what one takes from the authority itself, at 3928, Lord Hodge and Lord Sales set out the steps to be considered when considering whether particular losses fall within the scope of the duty owed. I would suggest that the 6 steps there, nothing really by way of a change in the law, but an identification of the process to be followed. At subparagraph 2, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? At 4, between letters G and H, is the loss for which the claimant seeks damages the consequence of the defendant's act or omission? And 5, is there a sufficient nexus between a particular element of the harm for which the defendant seeks damages and the subject matter of the defendant's duty of care? The duty nexus question. And then at 13, 3931, that they suggest that scope of duty question can be approached in a more straightforward way than was suggested by Lord Leggatt. And then in our view, the scope of the duty of care assumed by a professional advisor is governed by the purpose of the duty, judged on an objective basis by reference to the reason why the advice is being given, and as is often the position, including in the present case, paid for. So the focus is on the purpose, and that is then picked up again at paragraph 17 at letter H at 3932. Therefore, in our view, in the case of negligent advice given by a professional advisor, one looks to see what risk the duty was supposed to guard against and then looks to see whether the loss suffered represented the fruition of that risk. And Lord Leggett, although dissenting in relation to his approach to scope of duty, offered some guidance in relation to accountants. And my learned friend cites paragraph 115, 3959, where it thus follows from the purposes of statutory order, the auditor's duty of care is limited to protecting the audited entity and its members against the risk that its audited accounts are inaccurate. But then, of course, note the words in brackets, together with the risks of certain types of wrongdoing, such as in Lord Oliver's example, paying a dividend out of capital. So it's a reference back to Lord Oliver in Caparo. It's no part of the auditor's duty to advise the audited entity what business decisions it should make, nor to identify what considerations, apart from the accuracy of its audited accounts, are relevant for the entity to take into account in making such decisions. And then there's a passage often referred to, paragraphs 120 to 123, page 3961, which is dealing with the question of trading losses. But if one looks at paragraph 122, Lord Leggett has been analysing Court of Appeal decision in Asset Co and Grant Thornton, another audit negligence case, and he points out that the reasoning of the Court of Appeal there was unsatisfactory, as it amounts to saying only that but for the auditor's negligence, the losses would not have been incurred. This is merely the ordinary test of factual causation. And then at G, to conclude that the losses were within the scope of the auditor's duty, it was necessary to go further and find the losses arose from the matter which made the accounts and auditor's opinion on the accounts inaccurate. Now, applying that reasoning, those tests we submit are plainly met here. The defendants failed to detect the window dressing transactions that were designed to conceal misappropriations and huge related party balances. In the case of ACL, they failed to detect the breach of regulatory capital requirements. And in relation to AIML, they failed to identify that AIML was, with ACL's assistance, carrying out financial services in the DIFC without authorization. And those matters, in turn, gave rise to the DFSA fines. Had the defendants conducted a competent audit and had they reported correctly to those charged with governance, the members would have put a stop to the practices. So we say that it's the loss claimed, it falls squarely within the scope of the duty owed. There's some suggestion in the skeleton argument and in my learned friend's submissions that in some way the deliberate wrongdoing of the senior management is to be attributed to the company so as to prevent this claim in respect to the DFSA fines. But we know from the trio of Supreme Court cases, Stone and Rolls, Bilter and Singularis, that that's simply not the case. The deliberate misconduct of senior management is not attributed to the company for the purpose of a claim against the auditors, except potentially in a defined circumstance which doesn't apply here, namely one-man companies. That's of no application where, as is the position here, there are innocent shareholders and directors. So in our submission, the defendants are wrong in suggesting that it's not the purpose of an audit to detect and protect company shareholders from deliberate wrongdoing on the part of the management. That's a prime purpose of an audit. And they're wrong to suggest that the losses arising from the DFSA fines can't fall within the purpose of an audit. That's because the DFSA fines reflected the financial irregularities and misconduct which should have been identified and reported on by the auditors. My third point is that the defendants quote selectively in their skeleton argument from the ISAs. The defendants accept that they were contractually obliged to comply with the ISAs, but they then appear to suggest that it's only ISA 200 and ISA 240 that are relevant. Our claim, of course, we would say is entirely consistent with the requirements of ISA 200 and 240. But in any event, the defendants ignore a host of other ISAs that are applicable to the audits, including, to name but one, ISA 250. And we have that at 4244. and it's ISO 250 is International Standards on Audit, Consideration of Laws and Regulations in an Audit of Financial Statements. And then at 4249, there's requirements with the heading, the auditor's consideration of compliance with laws and regulations. Paragraph 12, as part of obtaining an understanding of the entity and its environment in accordance with ISO 315, the auditor shall obtain a general understanding of the legal and regulatory framework applicable to the entity and the industry or sector in which the entity operates, and how the entity is complying with that framework. And the auditor shall obtain sufficient appropriate audit evidence regarding compliance with the provisions of those laws and regulations generally recognised to have a direct effect on the determination of material amounts and disclosures in the financial statements. So here, non-compliance of the companies with laws and regulations had an obvious impact on the financial statements. Most obviously, if AML was conducting unauthorised financial services, then it simply wasn't entitled to carry on business in such a fashion, which in turn would go to the going concern assumption. But it also impacts on other ways, including the need, as we plead, for a provision for contingent liability in respect of a potential fine from the DFSA, and that being included in the accounts. Further, in the particulars claim, we plead and rely on ISO 260, which imposes the obligation on the auditors to report to those charged with governance on matters including any identified or suspected non-compliance with prevailing laws and regulations. And then, if the position isn't appropriately addressed, to modify or qualify the audit opinion. So in my submission, there's nothing novel or controversial about claiming for loss and damage in respect to the DFSA fines. Of course, Your Honour, all this will be addressed in expert evidence, and there may no doubt there'll be expert evidence on both sides in relation to how these ISAs play out in the context of this particular audit. But that will be a matter for trial. And then finally, my fourth point, developing area of law, we submit the claims have a strong claim in both contract and tort against the auditors for losses in respect to the DFSA fines. But even if that's wrong, and there's some doubt about this, I submit there isn't. This would be an example of a developing area of law within the DIFC, where per Lord Brown Wilkinson, this development should be considered on the basis of actual facts found at trial. It's quintessentially in that territory. And so in my submission, the application on both limbs, Your Honour, both in respect of the illegality limb and in respect of scope of duty application, should be dismissed with costs. There's one correction I noted over the short adjournment, or I was reminded of over the short adjournment. When I was dealing with Bilter, I referred to 5 law lords. In fact, there were 7 in Bilter. Lord Clark and Lord Carnworth agreed with Lord Newburger, so it doesn't change my submission, but there were 7 rather than 5. The reference is 3209 from my Lord's note. So, my Lord, unless I can help any further, those are my submissions.
Thank you, Mr. Hubble. Mr. Fenwick, in reply.
Thank you, Your Honour. My learned friend began by saying that this was all far too long and complicated for summary disposal, and including because of the number of authorities. And indeed, he's done his best to persuade you of the difficulty of reaching a conclusion by a number of authorities, in all of which what he's doing is firstly to try to persuade you that the long-standing bright line narrow rule in grey has somehow been superseded and put to one side by the trio of cases, in particular by Patel and Mirza, which I will have to go back to in order to explain why that is wrong and his reading of Henderson is wrong. But of course, what he's really concentrating on is the development of the law in England in relation to the extent to which claims for losses caused to a company whose management has been involved in wrongdoing can be recoverable either from those officers themselves or from third parties, including auditors, as opposed to the limited public policy question of whether or not one can recover a fine. And we will see when we look at those authorities that they don't change that essential bright line. You asked Mr. Hubble when looking at Henderson, well, if grey narrow rule was upheld, why did the court need to go on and look at all the other points? And of course, the answer to that is that in the light of the conflicting decisions which were brought together in Patel and Mirza, the courts were, when looking at a case under Grey, astute just to double check it to see whether there was anything in the three-stage test which caused doubt on the rule in Grey, and they found there wasn't. So it's not a matter of them applying the three-stage rule instead of Grey, it's a matter of them testing it. In the first case, dealing with the narrow rule, following the decision in Patel and Mirza. Now, I've got a lot of ground to cover, and I don't want to weary the court unnecessarily, nor indeed to drag us up until the last minute of our allocated time. So I shall try and deal with these as briefly as I can. And what I'm going to do is I'm going to try and knock off some of the points that my learned friend has made before we get deep into the authorities. Now, first of all, if we look at his last series of points, which are in relation to the scope of duty of the auditor, all the points that he makes there are points which will be relevant at trial to the extent to which this company, riddled with fraud, can in fact recover certain heads of losses from the auditors, and the scope of the duty of the auditors to discover and report on the errors in the accounts and the misstatements which can now be seen to be fraudulent. In other words, whether, had they conducted their audit properly, those frauds would have been uncovered at some earlier stage than they were. None of that impacts on the essential question of whether it was within the scope of duty of the auditor, not simply to examine the accounts, protect the company by providing it with information so that those responsible for its management could deal with it. Or you'll remember what Lord Leggett said in Manchester Building Society as to the limits of the auditor's duty, not the duty of the auditor to actually manage the company or control its business or its business decisions. And the question is simply whether that duty extends to preventing a company suffering a regulatory fine for its own wrongdoing, not a regulatory fine for something caused by the auditors, not a regulatory fine for which the regulator held the auditors were vicariously responsible, but a fine which was imposed on the company and on the company alone for its own wrongdoing. So in effect, it's put, as I said in opening, as the natural consequence of the narrow rule in Grey. It doesn't extend to other things, which we will no doubt debate at length at trial. Now, there are I think I rather lost count, his 9th or 10th point, some other compelling reason for a trial. And ironically, having spent several hours trying to persuade your lordship, your honour, that the DIFC court should follow the development of the law in England under Patel and Mirza, he flips his head and says, well, actually, you shouldn't follow the English law at all. You should fashion your own DIFC common law rule in order to decide what is the appropriate public policy in relation to regulatory fines. And he does that by a number of arguments, which I just want to pick up and put together. Article 6, which he poo-pooed as being rather inadequate, which is at 1823, which is very clear that you apply law, you agree, unless the parties agree that another law shall govern such dispute, provided such law does not conflict with the public policy and public morals. That emphasizes the fact that the DIFC has its own public policy and public morals. That public policy will have been derived from the sources from which DIFC draws its law, including the common law of common law jurisdictions.
Well, what's the basis? What's the basis for that proposition, Mr. Fennick?
The basis for that,
if there is no doctrine of illegality in DIFC law, how does the common law? It goes back to the Hamid case.
it does indeed.
There are constraints. There, the court said, well, you can't just invent a tort of malicious prosecution or abusive process if it's not in the law of obligations. So, how do we invent a defence of illegality to a contract?
You don't. The answer is you don't. Let's have a look at Hamid. You were taken to 4042, but if we actually pick it up at the bottom of 4041, paragraph 104, it's plain that the DIFC comprises a free zone with its own legal system, an enclave within the Emirate of Dubai. The selection of common law foundation of the legal system facilitates international investment by placing DIFC court within the same legal family as the major financial hubs internationally. Still further, as observed in Abdul Salam, the approach to DIFC court has been described as developing DIFC law and shaping principles taken from various common law jurisdictions. We underline nothing here should be taken as casting doubt on any of that. So that's the origin. And then it says, doesn't follow DIFC court judges are free to incorporate into DIFC law any common law development simply from any common law jurisdiction, simply because there's been such a development elsewhere, because the outcome might prove attractive in different common law jurisdictions. Internationally, the common law is by no means necessarily uniform. So you don't, what this means is that a novel tort, such as that of malicious prosecution, doesn't get brought in holus bolus and automatically into the DIFC. The DIFC has to consider it. So I do.
I must say I don't read it that way, Mr. Fennick. I read it as saying is a common law court, so common law principles will apply in terms of precedent, ratio decidendi, etc. But it doesn't mean that the substantive law is to be equated to the common law of England and Wales. That's quite a different thing. And so if the law of the DIFC is to be the contract law of the DIFC is to be found in the relevant statutory provision, and there is no defence of illegality, by what basis could we simply import a substantive defence that isn't provided for by statute, just because there is a common law, because England had such a defence for a very long time?
That is not the basis on which I suggest you should do so. I absolutely understand that careful identification of the independence of the DIFC's approach to developing its own laws. But we do have Article 56 of the DIFC Law of Obligations. That's 1925.
So that's a defence to a claim in tort.
That is a defence to a claim in tort. But that shows that there is within the law of the DIFC a rule against recovery in tort for loss or injury in the course of or as a consequence of unlawful conduct, or where it would be unlawful to obtain a remedy. So that is the DIFC law expressly adopting a public policy approach to the recovery of the consequences of unlawful conduct, and the recovery of a fine in a tortious criminal or regulatory fine in a tortious context would, in my submission, be barred by that rule in Article 56. Now, what Mr. Hubble says about that is, well, we've got to look at what's developing in England. Well, you can, of course, look at it, but you've got this clear provision barring claims for illegal conduct. That's part of the DIFC Law of Obligations. Now, what he says about the law of contract is, well, there's nothing in the contract law, the DIFC contract law, about an illegality defence. I accept there is nothing expressly in it. I'll explain in a moment why. But it would be, before one even looks at it, anomalous and curious and inconsistent if the DIFC court, applying the policy of illegality in relation to the law of obligations, concludes that there is no bar on recovering claims for the conduct of unlawful, for the consequences of unlawful conduct in a contract case. When most contract cases of the kind which we're likely to be dealing with here have a parallel existence in the law of obligations. So, and you get the curiosity that if your contract claim is barred, then the whole claim is barred. If the contract claim is not barred, then you can only claim in contract, because you can't claim in tort, because that's barred by the Rule 56. And that would be inconsistent. And unless there is a reason why the DIFC should not incorporate an illegality defence into the contract law, in my submission, it would be anomalous, inconsistent, and have absurd results if it did not do so. Now, can I back that up other than by reference to Article 6? Article 6 is enough to show that the law of the law of the DIFC should recognise public policy considerations. It should not, in my submission, recognise any public policy consideration which is inconsistent with and conflicts with the public policy set out in the law of obligations. But there is, as I indicated I would tell you, an answer to this. If we go to page 4043, and here we're back within Hamid. And if we look at paragraph 111, there can be no doubting English law, very much including English common law, has featured importantly in furnishing the foundation for DIFC law. Cannot be assumed merely because there's been a common law development in English law, any such development will be transplanted into DIFC law. For the same point expressed in a different way, which has reference to, for example, Patel. The source of DIFC law are not confined to English law, as readily demonstrated by the fact that DIFC arbitration law is based on the UNCITRAL model law, and the DIFC contract law is derived from the UNIDROIT principles of international commercial contract. Now, the (1994) UNIDROIT principles of international contract expressly excluded questions of illegality from their scope. Article 3.1, I don't think we have it, but you may be familiar with it. I can ask a copy to be provided to you. Expressly says, matters not covered. These principles do not deal with invalidity arising from lack of capacity, lack of authority, or C, immorality or illegality. And the commentary is that the article makes clear not all grounds of invalidity of a contract to be found in various national legal systems fall within scope, particularly the case of lack of capacity, authority, immorality, or illegality. The reason for their exclusion lies both in the inherent complexity of questions of status, agency, and public policy, and the extremely diverse manner in which they're treated in domestic law. In consequence, matters such as ultra vires, authority of an agent to bind its principle, and the illegal or immoral content of contracts will continue to be governed by the applicable law. So,
but if there is no law, then there is no law. The DIFC has no commercial law other than that passed by the DIFC, because it's a free zone and the UAE commercial laws don't apply. So the limitation on the terms of reference of the UNIDROIT committee might explain how the omission is there, but it's still an omission, isn't it? How do you? I still don't understand where that takes you.
That takes me to the point that there is a lack of an express reference in the contract law, and therefore the judges of the DIFC have to develop the law from a combination of long-standing common law principles, its own principles in Article 6, and the express parallel rule in the law of obligations. And if you sit there, as you do, Your Honour, as a DIFC judge, looking at a case which sounds both in the law of obligations and in the law of contract, and you're faced with an expressed public policy in the law of obligation, a general reference to public policy of an overarching nature in Article 6, and no conflicting provision in the law of contracts, then you should apply that same principle of illegality to contract law in order to prevent inconsistency and irrationality. And if you are, as you sit here, there is no case other than the case, of course, of
Veggie burger, is that what you're thinking?
Yes, veggie burger, which expressly refers to an illegality defence in a contract context. And it's perhaps we should just remind ourselves of that to show that the sorry, I just need to get my the pagination has changed so many times in the preparation of this case.
I think it's 3381.
It is 33366 and 3381, yes. Yes, it's 103 at least was void. Prohibited but wrong by law. The last one particularly compelling, strong enough defence matter to go to trial. Cannot speculate whether such an amendment would be granted. My point is the argument at least being void for illegality is a strong one. Here I refer to the defendant's citations, including Patel and Mirza. Finds defendant put forward a very compelling case. Performance of the lease was impossible in law. As a result, even binding on the Emirates would be unenforceable. Well-known contract, it must be a tenet of contract law, that a contract entered into for the purpose of doing an act prohibited by statute would be illegal and unenforceable. The argument of the apex of the defence, well thought out and clearly the correct application of the law. So,
but that's different. That's as Mr. Hubble pointed out. That's saying that if the contract is to do an act prohibited by statute, then it's illegal. But that's not the issue we're confronted with here.
No, it's not.
That's a different question.
It's a different question, but it shows that if something is illegal and prohibited by statute, it's unenforceable. There is a doctrine of illegality which applies there, and there is no reason why it should not apply in other contract cases.
Well, it is different things. You can easily see why, where the law of the DIFC prohibits something from being done, it's not a very long step to say that the same law precludes somebody recovering under a contract to do something that's prescribed. But you're running a quite different point. You're saying that it is part of the law of the DIFC that a penalty imposed by a regulatory body cannot be recovered as a measure of damage in a claim that's otherwise sound. They're really quite different things, I think.
They are different things, but where you have one different thing, but based on questions of illegality and public policy, where you have a prohibition in the law of obligations, and where you have a well-established, long-standing body of English law, and there are nobody is referred to any conflicting authority from any of the common law jurisdictions which suggests that you can recover in contract for a fine, then in my submission it is perfectly appropriate and sensible to look to the English authorities, as indeed both sides have in this case. And when you look at the English authorities, if, as I will seek to demonstrate, the authority in grey remains intact, then there is no countervailing public policy which should prevent that long-standing principle from being upheld in the DIFC. And the court, unless the court is going to develop its own freestanding approach to it, and to see whether the narrow rule continues to apply, then Your Honour has to actually reach a landing based on the materials available to you, which in this case, after extensive research, are in the bundles which have been provided to you, and you should follow that. I accept that you're not bound to follow anything in the law of contract. I can only show you the reasons why the contract law doesn't have an express provision, the general provision in Article 6, and the prohibition in the law of obligations. And just again, standing back there, unless Your Honour concludes that Article 56 of the law of obligation doesn't mean what it says, then if I am right that the narrow rule is a long-standing common law principle, then the court should apply it in relation to the tortious claims and strike out those tortious claims. It would be, in my submission, anomalous to strike out the tortious claims or give summary immediate judgment on them, but to leave intact the contract claims, because the two should proceed in parallel when the same policies are out. There can't be a separate, different policy in contract. No one has tried to identify one. Mr. Hubble made no attempt to do so. He simply said there wasn't such a rule. So, Your Honour, that's my answer to that point. We say you should follow the long-standing English jurisdiction. There may be some doubt, as expressed in Hamid, as to whether this court should follow all the way along the Patel and Mirza route. I'm not trying to dissuade you from that, because in my submission, Patel and Mirza is on this point consistent. It may well be that when we come to the trial of all the other issues, the DIFC judge trying the case will conclude that it's not prepared to go as far as Patel and Mirza in throwing out the Tinsley and Milligan line of authority on reliance defences of illegality, and restore some of the previous law. But for the moment, I'm saying we should look at the English law, and that Your Honour should be influenced by and decide in accordance with that law. So I'm going to go backwards to the next point that Mr. Hubble made, and this is his, I think it's 6 or it might be 7, the contradiction between my clients relying on the illegality defence to assert the narrow law that the fines cannot be recovered, and our defence to the claims, which, if you like, do not accept that we are in breach of duty in the same way as was found by the regulator authority when imposing fines on KPMG. Now, this is to misunderstand the case as it is brought, as I suspect Mr. Hubble well knows. In my defence, I am entitled to challenge the findings as not being binding on KPMG in a civil case for damages for breach of contract and breach of the law of obligations and the duty owed under the law of obligations. In just the same way, my learned friend is entitled to and does challenge a number of the findings of the authority in relation to the conduct of the companies, and says, well, that's not ours, that's our directors, that's not to be imputed to us. And although the fines and the decision making says this is your fault, they'll say it's not to be imputed to me. Attribution doesn't work in that way. Each of us is free to argue the case in relation to the rest of the claim and the heads of losses, and as to whether there's breach of duty and whether there's contributory negligence, whether parts of the claim are barred, and so on. However, neither party is entitled to assert an entitlement to claim the fine as part of its claim or counterclaim for indemnity. I can't claim under my indemnity for the misleading conduct for which the claimant companies are responsible, any part of the fines imposed on KPMG, and they can't recover any part of the fines imposed on the two entities. That's entirely consistent. Then there were a series of arguments based on strict liability offences. I accept, as I did in opening, that when you have a strict liability offence, it may be an exception to the narrow rule, or indeed the broader rule in Gray, to assert that there was no fault on the part of the claimant. The claimant was not in a position to know about the wrongdoing. Now, that is not a part of the claimant's case here. The claimant accepts that there was fault on the part of the entities for which it was vicariously liable, in just the same way as the other companies who were held to have been at fault and therefore unable to rely on the strict liability nature and its own innocence. And my learned friend talks a bit about innocent directors. Innocent but not non-culpable, because negligence and, in my submission, plainly gross negligence would not be innocent for these purposes of a strict liability offence. And these aren't, as Your Honour quite rightly observed, my learned friend's characterisation of deliberate and intentional misleading as being strict liability is not correct, even if in certain circumstances some of the offences, such as trading without the necessary authorization, could be a strict liability. On the facts of this case and on the findings made, liability was not imposed on a strict basis. Liability was imposed on a fault basis. And if we just take one of the authorities my learned friend relied on and said it helped him where summary determination was not given in favour of the defendant. That's a case of Owadali and Planology, which is Justice Collins Rice. That's at 4047. And it's important to note that this is a case which post-dates Patel and Mirza, and we see the claimants bought a listed house in Paddington to developers' flats, instructed defendants as planning consultants. Shortly after works began, the local authority ordered their cessation since they required listed building consent. Temporary preservation work were done, retrospective consent sought, not forthcoming. The claimants were in addition prosecuted for 4 strict liability offences, convicted and fined. In the present proceeding, the claimant sued the defendant for professional negligence, alleging that had been at fault, claimed, among other things, the criminal fines and costs and the effect of the disciplinary proceedings brought by ACCA. The 2 defendants applied to strike out, argued the claim either amounted to an abuse of process in that it sought to impugn the previous determination of criminal courts, alternatively it amounted to an illegitimate attempt to find a cause of action on the claimant's own wrongdoing. The judge refused the application, holding that there was an arguable case that the claimants had not known that their works would affect the character of the house, that in these circumstances the proceedings were neither abusive nor affected by the maxim ex terpi causa non oritur actio. And then if we go over the page to 3, equally, it could not be said the illegality defence was bound to succeed. The present case clearly involved the potential application of the narrower principle in Gray and Thames trains, that the consequence of a criminal conviction could not generally form the subject of recovery in later civil proceedings. So here the judge is applying Gray and Thames trains, despite Mr. Hubbell's assertion that it had been swept away. However, the precise limits of this principle were not entirely settled, especially in respect of cases where the conviction was in relation to an offence of strict liability, where a claimant alleged that advice had led to their being convicted. It followed the claim could not be found to fail on this basis. Gray, Patel and Mirza, Nosman discussed. So, and then it couldn't be said the judge led in principle in declining to strike out this aspect of the claim, since it did not cover the whole of the claimant's alleged loss. Decision to let the claimant's case as a whole go forward was defensible. Now, if we then go to page 390,
Bundle page 4053, I think.
Thank you so much. So this is where we get the case law on the illegality of defence in civil claims. 4 Supreme cases which County Court judge with direct are also an important focus of the appeal. Then we get Gray and Thames trains. Then 23, a narrower principle set out. Narrow principle based on avoiding inconsistency, where a criminal court fixes an individual with personal legal responsibility and punishment. A civil court should not lend itself to undoing that. And then, quote, so claims for damage caused by the lawful sentence of a criminal court within this narrow principle. Second is a wider principle which relies not on avoiding inconsistency, but on a general principle. The claimant, offensive to public notion, the claimant to be compensated for the consequence of his own criminal conduct. This may apply to claims for losses caused not just by the sentence of the criminal court, but by the wrongful conduct of a claimant. and then there's a distinction made. The claimant in grey was not permitted to recover. Then we get Apotex, and they quote Apotex. Then,
Sorry, Mr. Fenning, this is reply. You're reading authorities to me. I want to know what your point is and how it answers Mr. Hubbell's point. So
my point is
very long.
This authority, which he referred to and relied on, is an example of the judge actually applying grey with the potential defence based on offences of strict liability where there was no fault, which is the Osman case. So it's not a case where it's Patel and Mirza only. So that demonstrates that the thesis that Patel and Mirza has swept away Henderson, has swept away Grey and everything else, is simply not supported. Now, when dealing with the very extensive quotations that learned friend refers to in Patel and Mirza, there's nothing in Patel and Mirza which disapproves the existence of the narrow rule in Grey. And
what about the observations about not applying principles mechanically?
That is simply a general observation. You don't apply a principle mechanically. It doesn't mean to say that when you have a rule which is clear and to which there is no objection, you throw away that public policy rule.
Well, it's not entirely clear, because the case you've just taken me to, and you accept that the rule admits of an exception in the case of strict liability. Now, Mr. Hubbell says that a number of these offences are offences of strict liability. You say that when you go to the DFSA decision, it's appropriate to characterise as a finding of culpable conduct on the part of the company in respect of all the defences.
Yes.
Now, why isn't that a matter for trial?
Because the fine is not being imposed on the basis of strict liability, and you can see that expressly. So you can't change the fact that you may be able to say that there were defences open, or that some of the conduct shouldn't be attributed to the company for the purposes of the claim. But you can't say that the fine was not imposed because of the fault of the companies, because it was. So you don't need to go to trial to find that the fine was imposed because of culpable conduct of the company and the company alone, because it says so. Why do you go to trial to test that? How can you test it and find out something different? The case that I just showed you, Oswald Malley, is a case where from the outset, the claimant was saying, I didn't know about all this. I was wrongly advised. It was a strict liability offence, and I had no knowledge that I was committing it. Now, that's not what was found by the regulatory tribunal. It was not what was said by way of defence. There was no attempt to challenge it on the basis that the company was not at fault. The fines were accepted and paid. So you're not going to get a different finding at trial in relation to that. Just not going to happen. When you look at all the comments made by the Lord Toulson in Patel, and I'm going to have to ask you, I know it's a reply, but given the very extensive quotations and the lack of understanding the passages, Patel and Mirza starts at 3276. And I want to go to 3291, where Lord Toulson is dealing with Grey and Thames trains. We see that in that reference, Lord Hoffman expressing the maxim not as a principle but a policy based on a group of reasons. The courts had evolved varying rules. Couldn't simply extrapolate rules applicable to one situation applied to another. It had to be assumed that the sentence was what the criminal court regarded as appropriate to reflect Mr. Gray's personal responsibility for the crime. It was therefore right to apply the rule he couldn't recover damages for the consequence of the sentence, reflecting an underlying policy based on the inconsistency of requiring someone to be compensated for a sentence imposed because of his personal responsibility for a criminal act. It was also the right to apply a wider rule. You cannot recover damage which is a consequence of your own criminal act, reflecting the idea it's offensive to public notions of the fair distribution of resources. The claimant should be compensated, usually out of public funds, for the consequences of his own criminal conduct. Now, neither there nor later does Lord Toulson say that that is inappropriate and that that approach should be reconsidered. If we go to 3310, paragraph 108, well, perhaps we just look at 107. Considering with the district court refuse relief to which claimant would otherwise be entitled as a matter of public policy, various factors may be relevant, and there's a list of factors. Then 108, the integrity and harmony of the law permit and require such flexibility. Part of the harmony of the law is its division of responsibility between the criminal and civil courts and tribunals. Punishment for wrongdoing is the responsibility of the criminal courts, in some instances statutory regulators. It should also be noted under the Proceeds of Crime Act, the state has wide powers to confiscate proceeds of crime, whether on a conviction or without a conviction. Punishment is not generally the function of the civil courts, which are concerned with determining private rights and obligations. The broad principle is not in doubt that the civil court should not undermine the effectiveness of the criminal law, but nor should they impose what would amount in substance to an additional penalty disproportionate to the nature and seriousness of any wrongdoing. So here Lord Toulson, speaking for the majority, expressly stated that the distinction between criminal courts and statutory regulators on the one hand and the civil courts is that the broad principle that public interest requires the civil court should not undermine the effectiveness of the criminal law is a remaining principle which should be upheld. It is a bright line. That is the narrow rule. Then it goes on, but nor should it impose what would amount in substance to an additional penalty disproportionate to the nature and seriousness of any wrongdoing. In other words, over and above the fine itself, which they cannot recover because of that public policy, which is upheld and maintained by Lord Toulson's observations here, it would, there is no principled reason to use the conviction to prevent the company recovering other losses which it has suffered, even if those losses were suffered in part because of the criminal conduct, because that would be a additional penalty disproportionate to the nature and seriousness of any wrongdoing. So those cases, such as Stone and Rolls and the other ones which were swept away by Patel and Mirza, which were not involved in the question of the recovery of a criminal penalty or regulatory penalty or fine, but which barred the claim altogether, would be an additional burden. And that's what all these cases are about. It's dealing with the extent to which illegal conduct, criminal conduct within the claimant, which is itself a breach of the criminal law or regulatory law, should bar recovery from the persons who have responsibility for the wrongdoing, which of course includes both the directors of the company and auditors and other third parties. And there will be different rules and different policy considerations under Patel and Mirza between the position of the directors who, in this case, actually caused the wrongful conduct, because these claimants could only act through human agents, and those such as auditors, my clients, who may have failed to take action through negligence, which would or might have caused a different outcome and a better outcome. Now, I think probably I can now take you to, I just want to look and pick up before we go to Henderson at the Len Friend sought to challenge the findings in Apotex. We say, for the reason set out in our skeleton, that Apotex was another upholding of the principle of regulatory fines imposed on a company not being recoverable. And again, can we just look, please? It starts at 3176. And can we go, please, to 3189? Where Lord Sumption is dealing with Gray, and just below letter C, in Lord Hopman's view, two rules were relevant where the illegality defence was raised. Was a narrow rule, you cannot recover damages, and a wider rule. Then these words: the former test was operated automatically once it was ascertained that the loss claimed was a penalty imposed by a criminal court or the necessary consequence of the sentence, such as loss of earnings during a period of imprisonment. The latter test was simply a question of causation. Now, that's the distinction which I draw, and why this strikeout is based solely on the narrow test, because it applies automatically once it's ascertained the loss claimed was a penalty imposed by a criminal court. Now, it's not applied mechanistically because there is scope where there is a plea of no fault. I don't mean no dishonesty, I mean no fault on the part of the claimant, which has been fixed with the final penalty. But where there is clear conclusion by the regulator authority that there is fault, and where the claimant doesn't seek to say that there was no fault on the part of the company, then that narrow rule applies automatically. And that is what is held in the Apotec case. Now, I just want for a moment to refer to Bilter and Nazir, which is at starts at 3201. It's probably sufficient to look at the 3202 the fine dismissing the appeal. Most circumstances, the act and state of mind of its director and agent could be attributed to a company by applying the rules of the agency. Ultimately, the key to any question of attribution always in consideration of context and purpose for which the attribution was relevant. But where the purpose of the attribution was to apportion responsibility between a company and its agents so as to determine their rights and liabilities to each other, the result would not necessarily be the same as it would be in a case where the purpose was to apportion responsibility between the company and a third party. That where a company had been the victim of wrongdoing by its directors, or of which its directors had notice, that wrongdoing or knowledge of the directors could not be attributed to the company as a defence to a claim brought against directors by the liquidators in the name of the company on behalf of its creditors for the loss suffered by the company as a result of the wrongdoing, even where the directors were the only directors and shareholders, even though the wrongdoing or knowledge of the directors might be attributed to the company in other types of proceedings. Accordingly, the defence of ex turpi causa was not available to defendant directors against the company's claim. Now, of course, it's in that context that if we go to what Lord Neuberger said at page 3215 at paragraph 31, when he deals with Safeway stores, I would take a great deal of persuading the Court of Appeal didn't arrive at the correct conclusion in that case. I don't believe you'll be right on this appeal to express a concluded opinion as to whether the case was rightly decided, and if so, whether the reasoning of the majority or Lord Justice Pill was correct. It's unnecessary to reach any such conclusion. The points were not argued in detail before us. And the reason why Safeway stores met with concern and criticism is not because of the general rule that you can't recover a fine which has been imposed on you, but because the claim in Safeways was a claim by the company against its directors who actually committed the offence. And the whole thrust in Bilter was to affirm that where there was illegality within a company, the fact of such illegality committed by directors did not bar a claim against those directors. So you can't read it as a wider criticism of the rule in relation to recovery of a penalty. And you saw from the head note, and I'm not going to spend time in reply, taking you to the passages of Lord Hodge and Lord Tilson, that the finding was limited to directors, and for the purpose of a claim against directors, the wrongdoing of the directors was not to be attributed to the company, although it would be different in most other contexts. And in the context of a claim against a third-party auditor, there's nothing there which suggests that Safeway is not to be upheld. And that allows me to go lastly to Henderson, where learned friend cannot in my submission get the support from it that he claims to do and seeks to do. Now, first of all, you asked the question as to whether it was a strikeout or a case for immediate judgment. It was the equivalent of that. If you go to, it starts at 3850. And if we could go please to 3864. Paragraph 23, the trust position of the entirety of the claim, including all 6 heads of loss, should be defeated on illegality or public policy grounds. The master ordered there to be a trial of a preliminary issue to determine whether some or all of these 6 heads of claim are irrecoverable on the grounds of illegality. After hearing argument over the course of 2 days, Mr. Justice J handed down judgment. So it was, in effect, a immediate judgment type claim by way of a hearing of argument on preliminary issues. So no different in substance, although it may have been in form, to the course that your lordship is taking. Now, in the decision, this judgment of Lord Hamblin, and I'm just sorry, my at 3897, we get 3896, Lord Hamblin going through Gray and the narrow rule. 41, how he affirmed the narrow rule and held that it barred the narrow claim, and then went through some of the other decisions, and then if we look at uh, 3902, where he finds, he makes the following observation on the judgment given in Gray, insofar as they relate to public policy. Narrow claim and wide claim failed on grounds to avoid inconsistency, not to the wide claim. 4, on the next page, public confidence applicable to the narrow claim. and then support 59, supported by Lord Sumption in his dissenting judgment. And when he comes to deal with Patel at 3904, Lord Toulson identifies two main policy reasons for the defence of illegality. One is that a person should not be allowed to profit from his own wrongdoing. The other linked consideration, the law should be coherent, not self-defeating, condoning illegality by giving with the left hand what it takes with the right hand. In other words, a giving with the left hand through civil proceedings, what's taken with the right hand through the criminal proceedings. And then at 68, his conclusion, the essential rationality is it would be contrary to public interest to enforce a claim if to do so would be harmful to the integrity of the legal system, possibly certain aspects of public morality, the boundaries which have never been made entirely clear. He's talking again of the need for the integrity of the legal system. And then we just need to look at 3907. And this is an important paragraph that my friend Mr. Hubble didn't take you to. That does not mean that Patel represents, and this is where Lord Toulson set out his three-stage test. Patel represents year zero in all future illegal.
Mr. Hubble did take me to that paragraph.
Did he? Oh, I'm sorry. I thought he hadn't. But here he says this is disregarding the value of precedent built in various areas. Those decisions remain of precedential value unless it can be shown they're not compatible with the approach set out in Patel. In a sense, they cannot stand with the reasoning in Patel or were wrongly decided in the light of that reasoning. He made it clear in Patel the principles he identified were to be found in the existing case law.
Mr. Fennick, this is the second time tonight that paragraph's been read to me. What's the point you want to draw from it?
But the point I want to draw from it is this, that preceding decisions, such as Gray, are of precedential value. That is to say, they stand as precedents to be followed unless it can be shown they're not compatible with the approach set out in Patel and don't stand with the reasoning or were wrongly decided. So, what's important about that is that when Lord Hamlin and the Supreme Court in Henderson analyze Gray, consider it and to see whether it's compatible with the approach set out in Patel and find that it is. And when they uphold it and uphold the narrow principle in Patel, that is the exercise which confirms that Gray and the narrow rule in Gray is a continuing valid precedent because it's not incompatible with Patel. So
it's a precedent on facts that are comparable to Gray. That's the point I think that is being made in paragraph 77. You look at the facts of the case and you see that if on those facts, then the outcome is consistent with Patel, then the case is a precedent for other cases with those facts. Now, the facts of Gray are very different to the facts of this case. So I find it hard to read that paragraph as saying we are upholding the strict rule in Gray to the effect that there are no circumstances in which a penalty can be recovered as part of damages for a wrong, because it just doesn't fit, I think, with paragraph 77. But I understand your submission.
Well, if you go to paragraph 94, well, 93, Gray was correctly seen in Patel as being an example of a decision based on illegality, based on policy considerations rather than reliance. So it was the policy. In addition, the fundamental policy consideration relied upon in Gray was the need for consistency so as to maintain the integrity of the legal system, the very matter that was held in Patel to be the underlying policy question, which is why I took you to those questions about the integrity of the legal system referred to by Lord Toulson. So the facts in Gray in terms of manslaughter caused by injury may be different from regulatory fines. They're not different from les laboratoires and apothèques. But the principle on which it is decided that the penalty itself cannot be recovered is an underlying rule, which is here fundamental policy consideration, which is consistent with Patel. So it may well be that different considerations to Gray or Henderson would come in a different case in relation to other claims flowing from the unlawful act. But the claim for the coherence of the law between the criminal law and regulatory law and the civil law in relation to the actual recovery of the fine is not a matter which requires analysis of the facts. It is the same principle. You don't get the fine back. You may be able to recover for other damages, notwithstanding your conduct which led to the criminal conviction, but you can't recover the criminal conviction. You can't recover compensation for your time in prison. You can't recover a fine which has been imposed on you. That underlying principle is not challenged. And if it had been, then what Lord Hamblin would have said here and what Lord Toulson would have said in Patel and Mazza is, although the principle in Gray may apply to that kind of case, it should not be taken as a principle of general application. The narrow rule which has been applied both before Gray and after Gray, as we've seen in apothèques and other cases, should be reconsidered. And they didn't do that. And they didn't do that because they considered that that narrow rule still applied. Your Honor, I think the last thing I need to just deal with is this claim by Mr. Hubble that when you look at the three-stage test in Patel, for some reason, its public policy should be upheld because of the insolvency in creditors. I make 3 points. It is clear that the company was at fault. That is first factor of Lord Toulson. The public policy deterrent effect. It's not an answer to say this lot won't be deterred because they've been removed. It is a deterrent to all companies in the DIFC, in the financial services sector, not to breach these regulations. And in just the same way as the fact that a wrongdoer has committed suicide doesn't mean that his relatives can say, well, we don't need to worry about the deterrent effect on him because he's committed suicide. Please allow us to recover despite his wrongdoing. It is the deterrent effect is necessary to deter all those involved in this industry from this kind of conduct, and it is that which led the regulator to explain why they were imposing such a serious fine. And thirdly, this question of creditors and proportionality. It is a falsity and indeed it's heretical to assert that you make a different finding depending on whether or not the persons ultimately affected are innocent or are not at fault or should evoke sympathy and proportionality. If these companies were still solvent, if their claims are that they would have continued, and that's a claim which is made, they would have continued and they would have survived, and thus there would have been a surplus for the shareholders. If there had been no question of insolvency, then you apply the rule rigidly. It doesn't mean that you apply it not at all, simply because the company is in liquidation and you're now dealing with creditors. Because almost every company where there is such fraud will end up being insolvent and with creditors or investors losing. That is not a reason for departing from the rule, which we say on all the tests should be. Your Honor, I think I've covered every point, unless there's something I can assist you with.
No, thank you, Mr. Fennick. Obviously, I'll reserve my decision, but I'd like to talk about costs. Both sides have submitted statements of costs. Do the parties want to make any submissions in relation to the statements submitted by the other side or in support of their own claims?
We did written submissions last time after the judgment.
I wonder whether we'd certainly be in favour of summary assessment, Your Honour. I wonder if brief written submissions following the judgment could be a way of dealing with that.
Mr. Fennick, are you happy with that?
I'm going to let Mr. Montague-Smith deal with that, if I may, because you've been looking at it more closely than I have.
All right, Mr. Montague-Smith.
Yes, that sounds like a sensible proposition.
Right. Brief written submissions followed by immediate assessment after the determination.
Understood.
Yes, all right.
And
all right.
Your Honour, could I possibly, forgive me, mention very briefly one case management point that it struck me I should state our position now, and that's, you very kindly raised the question of docketing in the context of what will be a long trial, the 10-week trial, and it struck us reflecting overnight that there might very well be benefit in keeping a flexible approach at the moment in relation to how that trial will take place. Your Honour, you and my learned friend Mr. Montague-Smith contemplated that the whole trial would be in person. It struck me that there might be sense in keeping flexibility in relation to that issue, and that might help with identifying the alternative judge. For instance, and I mention this only as a possibility, you could have certain aspects, anything involving openings and closings could be remote, evidence could be in person. That would be one approach. It just struck me that this is probably something that would require a bit more thought and a bit more thought to what flexible approach we might be able to adopt. And
the other thought that occurred to me along the same vein is whether it might be better to break the trial up into two chunks and have one chunk before Christmas, then a bit of a break, and a chunk after. But again, I know that's disruptive to council schedules and so forth, but it might be something to think about.
Yes, but perhaps. Well, I just wanted to make clear that we would be flexible, and we think that this probably does merit some further thought.
All right. Well, that might make it a bit of an easier sell for me, Mr. Hubbard.
Well, I had that in mind. Your Honour.
Well, and I mean, from our side, I don't think we had envisaged that you would be making any orders at all or any final decisions. I think, generally speaking, this court's policy is that anything over 4 days will likely be in person, but quite obviously, it'll depend to a large extent on what the judge wants, whoever that may be. I think our preference would be as much as possible in person, certainly for the witnesses, but frankly, it just depends on the judge and what's useful to them. But my experience has been that quite a lot of judges find it more useful to have the advocates there in person, as one DIFC court judge said it, so they can look us in the eye and we can see the twinkle when they don't like what we're saying. But for whatever the reason may be.
Well, another possibility, and this is really getting heretical, it's probably because it's late at night where I am, would be to hold an in-person hearing, but not in the DIFC. In other words, the court could sit offshore if the body of people were all in England, including the judge, counsel, expert witnesses. It might be more cost effective to actually run the case in England. But
it's not so heretical. It's not so heretical as you think. That has happened on at least one occasion.
As I understand it, the court would need permission from I think the president of the DIFC to do that. But in an appropriate case, I think that could be obtained.
We actually, as an aside, we actually had a very interesting trip way back when Sir Anthony Evans was the Chief Justice to the Foreign Office, when Daniel Bethlen was the Chief Legal Officer, and because the concern was whether or not the UK would have any problems with that, and he confirmed that they would not, and so hearings have been held with judges sitting in London.
Perhaps again, parties might turn their minds to whether that's a practical.
That's very helpful, Your Honour. Thank you.
Thank you.
All right. Well, obviously, I'll need to reserve my decision. I'll need to write reasons. I'll do it as quickly as I can, but I've got a few other things on my plate at the minute. And it's not going to. We've all agreed. I don't think it's not going to interfere with the course of the procedural steps from here. So I'll get around to it as soon as I can. And thank you. I'm very indebted to counsel and for all of those who assisted counsel, who actually did the oral argument, for their assistance in presenting such an interesting set of submissions and such an interesting set of issues, which I found really interesting. So I'm very grateful to all of you for the diligent effort you've applied to the task. So thank you, everybody, and court's now adjourned.
Thank you, Your Honour.